Yes. And your application date was fixed on 11th August. Yes. Yes, sir. Yes. But this is the matter when I'm suffering and some sort of interim order by the appeal court after right from the 2003 before all other courts. You understand some last chance lordship gave them in September. The number of heads are more than the number of weeks, number of days in the week. So we cannot allocate separate heads for days for last chance lordship because twice it appears lordship didn't take up because the other side was wrong. Let us see whenever it's called in. Some business I don't say whether any date lordship is no objections.
Item number
Yes.
item number 180 today's
Yes.
But I am paying that for today's accommodation.
If it is called on, please ask someone to ask for 10.
May I mention item number 72 of my lord's list today? This is appearing under the heading hearing civil. My lord, should my lord appear under assigned matter? My lord, in fact, my lord was pleased to hear this matter on 23rd December.
It's an assigned matter, but yes, it was hearing.
Yes, my lord. My lord heard it last on 23rd December.
Order the hearing.
The direction was to put it under the hearing. The assigned a lot of headers. Assigned.
Item number 1 for judgment.
Accordingly, if number 190 of 2020 is allowed on contest, they were setting aside the impugn judgment and decree to take certain set and decreeing the state by granting dissolution of marriage between the parties by a degree of divorce. Simultaneously keeping in view the rights of the respondent husband and the welfare of the minor child of the parties. We hereby grant visitation right in respect of the minor son of the parties to the respondent husband till the said minor son attains majority. The respondent husband shall be entitled to visit the minor son of the parties once a month on the first Sunday of each month for a period of 2 hours between 3 p.m. and 5 p.m. If the respondent so approaches the appellant wife shall grant such exclusive visitation right to the respondent husband in respect of the child. During the visitation hours, the respondent husband shall have an interaction with the minor son in any public place within a radius of 2 kilometers from the then residence of the appellant without any interference by the appellant wife. However, the parties shall strictly adhere to the timelines and the respondent shall return the son to the appellant wife within the appointed hour as per the above direction. In the event for some unforeseen reason the visitation cannot be implemented by either of the parties, advance notice of at least 48 hours shall be given by such party to the other by arranging the next available Sunday in the same month for the purpose of the missed day of visitation. It is expected that the parties shall be sensitive to the sentiments of the minor child and shall not do anything which would be detrimental to the interest and welfare of the child. Interim orders, if any, stand vacated, no orders to cost. Applications are also displayed.
Item number 2 for judgment.
Hence, FA number 103 of 2023 is dismissed on contest, thereby affirming the interim judgment and decree to such and decreeing the divorce suit, granting a degree of divorce in favor of the respondent husband against the appellant wife. No orders to cost, interim orders, if any, stand vacated. Can shall also disposed of, made clear that nothing in the above judgment shall create any impediment on the part of the parties, if otherwise entitled to in law, to apply for permanent alimony in the jurisdictional court. Formality.
Item number 3.
In the judgment dated January 6, 2026, The date of the judgment has been wrongly mentioned in the caption as January 6, 2024, whereas the same should be read as January 6, 2026. Bishop, let the said judgment be deemed to stand corrected accordingly.
Item number 4.
Pursuant to the direction of 24th December 2020.
That check.
Got to check. Clear on it. Demand of one for one.
Yeah.
Member International C. I pray it for member specific performance of an MOU that is member dated 9th February 2017. You can visit member that certain properties, some freehold, some leasehold, by my learning friends bank were to be transferred to me against a total consideration of 6 crores. Our extortion banking of an MOU at page 499. It says that on the basis of the representation, the virtual banking clause 9 of the MOU, that page 5 here, can 1.
Yes.
It says that the title in respect of land 1 and land 2, that is freehold leasehold, have been verified by Punra, that is my client, in the various documents already submitted by Mr. Saranjit Singh, that's my learned senior principal. On that basis of the document they had furnished, we had ascertained that the title seems to be correct. And on that basis, the agreed consideration, what you will find mentioned, is 7 crores, of which 50 lakhs had already been paid. Subsequently, when we transferred, we made an independent inquiry that there are certain defects in the land. On the basis of that, further negotiations were carried out between the parties. Now, the crystallized figure is 4.5 crores.
You have agreed, both of you have agreed.
There is correspondence on that effect, but I will have to amend my claim to bring that on record. So I am only saying, that the total sum in consideration for the settlement now has to be adjudicated. Whether it will be standard 6-7 crores or whether it will stand at 4.5 crores.
But as on today, the sum stands at 75.
On the basis of my pleadings in the suit, yes, it is 7 crores. But there are things that I will have to bring on record. I also have
to file an application for amendment.
I shall do all that. I'm only in these circumstances, I'm only saying that the demand that your lordship directed me to furnish, in that be deposited with the registrar and not tendered to my learned friends. At this juncture, because there are issues to be resolved in the only that
appears to be correct. Because why should we direct you to pay?
No, I know. The only thing, this MOU was entered in 2017. There was a timeline to final conveyance within a year and 18 months. They did not do anything.
This is only to ascertain the readiness and
No, I know. But there's an injunction on me.
This will be subject to the.
But there's an injunction on me to alienate a third party interest on the property, which is my lord has passed. Today, my lord, I have terminated the agreement. I have not filed opposition yet to the CAN. Now this submission is made that 4.5 lakhs, the title is in dispute, there's nothing on record.
If they file an application, will consider you can contest that application for
in the court bill. In the court bill. But the injunction remains.
This is against
Yes.
We'll have to file that injunction in the court bill. The amendment in the court bill.
Yes, I shall. So these readings, these prayers which are being made now, are not part of the.
No, we understand.
They're saying
that.
They're saying these documents which are
as per the agreement, the constitution is 7 crores.
7 crores. They seek a specific performance on this agreement of 7 crores. 7.5.
What is the amount for which demand draft has been brought?
1 crore.
That was the rate.
Now, only that even they are saying that according to them, the agreed consideration is 4.5, which I dispute.
Obviously.
Which I dispute.
If they file an application for amendment in the trial, that is allowed to be considered.
Yes. Now, only thing was that today the amount paid to me is 50 lakhs. 1 crore pay order is here.
They'll put it with the register.
They'll put it with the register general. So, for the balance amount is concerned, because let's see what happens.
That will decide at the final hearing of appeal, because this is not even against the final degree in a suit. So,
the appeal, I think the appeal will be keeping the appeal pending.
We'll dispose of the appeal. So then let us dispose of the appeal.
Yes.
So then not the registrar general, then in the trial. The deposit will be made in the trial court, which will be subject to the outcome of the appeal.
Now, I am saying a deposit of a higher amount. deposit of a higher amount because well, they say a 4.5 crores.
For the time being, 1 crore is.
Now the so far documents are concerned, but what they are saying today is not on field. Now they have only paid me
So
50
we are not
lakhs.
going by 4 crore 50 lakh. We are not going by that. As per our previous direction, they are putting in their deposit.
But I say that the last two occasions,
Yeah.
parties agree that we will go for amicable settlement. It's recorded in my lord's two
We
orders.
can do that in the trial court when the matter is.
We approached the broken on record for the appellant that fix a settlement meeting date. Nothing was done. Now a new case has been brought to the court that's settled anytime. No, I'm saying from day one. I'm saying from day one.
When settling, we are not standing in the way.
No, settle anything you want. No, that is the figure is now from 7.5 crores coming to 4.5 crores. That's what you agreed. We got the documents. No, it is not on record. These documents are not on record. We put it on record. These documents are not on record that we have agreed. Your message is not even ours. Now, the case that you made out in the court below and the plaint is not on 4.5 crores. The case made out is on 7.5.
We will direct to file the written objection to the injunction application in the trial court within the limited period. We just request the trial court to-
Only another thing,
Yeah.
my client is around nearly 80 years old. 83.
We request the trial just to
Yes.
consider the application at least at this stage. It is yet to be.
Yeah, because this will take, I know this will take for 10 years. And so far the promoters are the developer is concerned, they are not in a hurry. The developers. So, and my client may be in a hurry. Because they are not in a hurry from 2017 to 25. Why they will in a hurry? They paid me. No, there is nothing on record. We have not replied them. From 2017, the first letter which comes from them is in 2024.
You terminated it.
Nothing on record.
The present appeal arises out of the refusal of an interim prayer for injunction made by the plaintiff stroke appellants in a suit for specific performance of a contract. To sub next para, the senior counsel appearing for the appellant submits that although initially the agreed amount of consideration was rupees 7 crore, comma, 7.5 crore, comma, subsequently the appellants found that there were certain defects in the title and as such, comma, there was correspondence between the parties reflecting that the consideration amount should be decreased to rupees 4.5 crore. To sub next para, however, comma, it is candidly submitted that such pleadings are not yet there in the trial court, and the plaintiff stroke appellant seek to amend the plaint to that effect. To sub next para, learned counsel appearing for the learned senior counsel appearing for the respondents disputes such contention of the appellants and contends that the appellants have filed the suit for specific purpose for performance of the agreement in which consideration was mentioned as 7.5 crore and as such cannot reside from such position. To sub next para, that apart, comma, it is submitted that although there were attempts to have the matter mutually resolved, comma, no such effort has been shown by the appellant, comma, which is again disputed by the appellants. To sub next para, be that as it may, comma, the appellants are ready to put in a demand draft to the tune of rupees 1 crore as per our previous direction to show the readiness and willingness of the appellants to have the agreement performed. Full stop. As such, comma, we are of the opinion that in view of the appellants having shown prima facie their bona fides with regard to readiness and willingness, comma, uh, in view of disputed questions of facts being involved in the suit, comma, there ought to be an order of injunction, semicolon, otherwise, comma, the suit might be rendered, the injunction application and the suit might be rendered infractuous. Full stop. Hence, comma,
Now, she is granting the order.
yes,
So nothing will remain in the 39 Marine to before the court.
everything will.
So I can go and simplicity file it.
Accordingly, FMAT number
He was
260.
disposed.
Accordingly, FMAT number 260 of 2025 is disposed of, comma, along with the connected pending applications, where can 1 of 2025 and can 2 of 2025 by passing an order of addictive injunction restraining the defendant's respondents from acting in breach of the MOU in question, dated February 9, 2017, by dealing with, disposing of, alienating, encumbering, parting with possession, or creating any third-party interest in respect of the subject matter of the said MOU, dated February 9, 2017, till disposal of the temporary injunction pending in the trial court. To sub next para, the defendant stroke respondents. Now, the above order shall be subject to the plaintiff stroke appellants depositing the demand draft produced before us today in the trial court within a week from date. Full stop. Next para. As and when deposited, the said amount shall be uh, uh, deposited in an interest-bearing account, short-term deposit stroke account by the learned trial court, and such amount shall be subject to the final outcome of the suit. Next para. The defendant's respondent shall file the written objection to the injunction application in the trial court within 3 weeks from date. Next para, it is expected that the injunction application shall be disposed of upon giving opportunity of hearing to both parties on merits within by the end of February 2026. Next para, in view of the advanced years of which response?
17C. The plaintiff number 1. So different number.
Age of the defendant stroke respondent number 1, we expect that the learned trial judge shall dispose of the suit itself thereafter as expeditiously as possible, preferably within 1 year after the disposal of the injunction application. Next para, we make it abundantly clear that this court has not entered into the merits of the matter conclusively, and it will be open to the learned trial judge to dispose of the injunction application as well as the suit independently on their own merits without being influenced in any manner by any of the observations made in this court and or the admitted injunction passed by us. Next para, your rest for satisfaction.
Look, there's just one problem. The demand draft is in the name of my defense firm. Because we have to put in it will be
In the name of in the suit.
it has to change. So that
আচ্ছা একটা লাইন অ্যাড করে যেখানে বললাম যে ডিমান্ড ড্রাফট শ্যাল বি ডিপোজিটেড উইদিন উইক ফ্রম ডেট ইন দি ট্রায়াল ওই সেন্টেন্সটা প্রশ্নের পর since the demand draft has been prepared in the name of the respondent number 1, on the prayer of the appellants, the appellants are granted liberty to make appropriate changes to the demand draft and or furnish a fresh demand draft appropriately, to the credit of the suit in the trial.
Item number 5.
Yes. Thank you. Thank you. Yeah.
My argument. One thing is about that during the pendency of this appeal, but I filed an application for injunction.
Right.
Now, in the opposition to the injunction application, they have disclosed that the notification under section 4(1)(a), although they have not annexed, published in the Calcutta Gazette. That is at page 43. If you can see at page 43 of the supplementary paper book, page 43.
Yes. That is the affidavit of opposition.
Yes. Number also can come to the inner page, the running page 47.
Yes.
Roman 4. Notice under section 4(1)(a) of the State Act bearing certain such was published in the Calcutta Gazette on 1978. So the above requisition land measuring certain such records has been listed in the state from all other section 4 of the Act. My simple submission before your lordship is this, that even assuming there was although they have not annexed the notification, there is a notification. But that notification, effect of that notification stood last for want of declaration of the award in terms of section 7 capital A of Act 2 of 1948. If you also kindly turn to the section 7 capital A once, 7 capital 1, that is the 7 capital A of Act 2, the later part, page number F48. F48.
Yes.
The collector shall make an award under subsection 2 of section 7 within a period of 3 years from the date of publication of the notice in the official gazette. Under subsection 1A of section 4, referred to as the said notice, and if such award is not made within the period as aforesaid, the said notice shall lapse. Meaning there will not that notice for acquisition will go. The moment notice for acquisition gone, then my lord, the vesting also gone. My lord, that is the clear finding of our special bench. Where judgment has already been handed up to must be in the file. The reported in, my lord. Reported in 19 yes, 2011 volume 3 CHN Calcutta civil file. 2011 volume 3 CHN Calcutta civil file. Special bench judgment. 555. Just got it.
2011 was not cited. We have got 4 judgments. One is 2009 2 CLJ, 2016 6 SCC, 1992 2 CLJ,
Yes.
and 2012 1 SCC 792. These are the 4 judgments we have, which are held.
Now, kindly have a look at the judgment. The effect of the notice is also taken now. What is the effect of the notice if the award is not being passed within the stipulated period? As I shown to your lordship, there is no valid award. As has been tried to shown that a calculation sheet is an award, but I submitted because that is not an award at all. So therefore, other than that, there is no other scrap of paper to show that award has been declared. If that not be so, then what is the effect of the notice under section 4(1)(a) in terms of section 7 capital A? Practically turn to in the earlier part, amendments and everything has been quoted in the judgment, special bench judgment. And at page 562, section 7 capital A has been quoted. At page 562. Yes. Next page, my lord. Section 7 capital A has been quoted. Then lordship kindly turn to page. I am skipping over this for a moment. Kindly turn to page, my lord, 28. There 23.
Paragraph.
Yes.
Yes.
With great respect to the division bench, we are unable to accept the above interpretation of the Amendment Act of 1996. Although the said act was published in the Calcutta Gazette on October 8, 1996, the division bench totally overlooked that in subsection 2 of section 1 of that very Amendment Act, it was specifically provided that the said Amendment Act should be deemed to have come into force on April 1, 1994. Moreover, after the provision to section 7 capital A, the date 3/1/31/3/1994 was specifically mentioned after the word that act, which totally escaped the notice of the state division bench as it appears from the quotation of the state proviso. Thus, there is no scope for interpreting the word that act at the as the Act of 1990, ignoring the date of commencement of the West Bengal Land Acquisition Amendment in 1994, specially mentioned at the end of the proviso, where the intention of the legislature was clear. There is no scope of ignoring the specific language involved with the statute. Thus, by the Amendment Act of 1996, the proceeding in respect of the notices given prior to 31st March 1992 should lapse if award was not published within 1 year from March 31, 1994. Therefore, my respectful submission before your lordship with this. If they can satisfy your lordship, a calculation sheet tantamount to a declaration of award, then I am out of court. If that not be so, in terms of 7 capital days law, the notice for acquisition gone. If that gone, my lord, there cannot be any further proceeding without taking the recourse of the other amendments. And to this, my lord, I am relying this judgment, my lord. And so far, my lord, the cost of litigation can excuse me, my lord, that service of 90 order under section 3 is mandatory. But I have already cited, my lord, 1992 to CLJ, page 267. Para 50.
What is mandatory?
The notice, service of notice under section 3. The notice for requisition. Subsection 2 says, my lord, that is the mandatory. And admittedly, my lord, that was not been found.
Yes. Yes, sir. Yes, Mr. Waldo. Yes.
Lord, my submission is not questionable, my lord, for the honorable. Sir, they have challenged the order passed by my lord of such a joke, which is under challenge before your lordship. 25th July 2020. May I read the
25th July 20?
25th July 2020.
Yes.
May I read the judgment, sir?
Which is the page number?
Page number 77 to 86. Of the paper 1. It starts from your
Page 80.
1 minute.
No, you're right. Page 80. Page 80.
It
Yes.
starts from it. We are very.
Please.
The present petition has been initiated based on letter dated 31st October 2018, issued by the additional district magistrate Ela, District Land and Land Reforms Officer Malda, addressed to the Block Land and Land Reforms Officer Rajul Malda for recording acquisition land of the petitioner in favor of the Irrigation and Waterways Department, Government of West Bengal. Mr. Tulsi Das Rai, learned advocate, representing the 3 petitioners. We are kindly noted 3 petitioners, being sons of late Honorable Dasi, has submitted that the land in question was possessed and enjoyed by the petitioner till issuance of such memo dated 31st October 2018. For recording the land of the petitioners in favor of the Irrigation and Waterways Department, Government of West Bengal, it is the contention on behalf of the petitioners that based on notice under section 3(1) of the West Bengal Land Acquisition and Acquisition Act 1948, herein after referred to the Act 1948, the proceedings might have been initiated for requisitioning the land of the mother of the petitioners, but such proceeding was not concluded and no compensation award was paid in favor of the mother of the petitioners at the material point of time. Upon presenting this petition, it has been prayed by the petitioner for setting aside the acquisition of land measuring 2.57 acres in RS number 16, number 33, Muja Ramalvita, in Malda. Mr. Sumitra Bangabata landed advocate is presenting the state respondents that oppose such prayer of the petitioner from the amendments made in the affidavit in opposition to the petition. After placing reliance on the relevant part of the affidavit in opposition, it has been submitted. The land of the mother of the petitioners was acquired in connection with its LA case number 28 of 1976-77 for construction of stack yard in connection with the Tirtha Barrage project, and possession was handed over to the requiring body on 21st August 1976. Based on such steps taken by the authorities, calculation sheet was prepared in connection with the LAPs by Land Acquisition Department for payment of compensation award to the mother of the petitioners, namely Konokolata Bashi. Ultimately, it has been submitted on 23rd August 1984. Award money was paid to the mother of the petitioner to the tune of 761. But this amount is wrong. But this is not a correct amount.
What is the correct amount? Sir?
39,000 and lateral by
30,
39,000. Lateral by place because
39,000.
but this is not that is wrong yet. I have shown because I shall
Okay.
for acquiring the land of the petitioner's mother in support of the same documents has been annexed to the affidavit in opposition in annexure R3. It has been submitted that 100% payments. Kindly note. It has been submitted that 100% payment of compensation has been made as per the relevant provision of the Act 1948. Subsequently, based on letter dated 31st October 2018, issued by the additional district of the Ela district landlord and reforms addressed to the block landlord reforms of Rajol Malda Satansa relating to recording the name of the irrigation and waterways department government of West Bengal in the record of rights based on the acquisition proceedings initiated by issuing notice upon 3/1 in the year 1976. Petitioners cannot have any right to agitate the issue afresh. It has been done in the present petition. This court has heard the learned advocates representing the parties to the petition and peruse the relevant materials available on record. It appears that on notice under section 3(1) under section 3(1) under the said Act of 1940 issued in connection with the LAS number 28 of 1976 for acquiring land of the mother of the petitioner. Upon placing a reliance on particular document, which is annexure R3 to the affidavit in opposition issued on behalf of the state respondent, it has been contended that the state award money, was paid to the mother of the petitioner on 23rd August 1984, and prior to that, possession of the land was handed over to the requiring body, that is Sub-Assistant Engineer Irrigation and Waterways Department, Government of West Bengal on 21st August 1976. Since the entire proceeding under the relevant provision of the state Act 1940 was complete by handing over possession of land on 21st August 1976, and subsequently award money was paid to the petitioner 23rd August 1984. This court possessed queries to the learned advocate representing the petition as to why the petition was filed on 18 September 2019. This court does not receive the satisfactory answer on the delay made by the petitioner in approaching the court for closing the acquisition proceeding, which has been initiated by the concerned respondent authorities in terms of the Act 1948. From the facts of the case, it appears that the requisition proceeding was initiated against the mother of the petitioner by issuing notice under section 3(1) of the Act on 12th August 1976. Petitioner's mother died on 9th October 2000. Well, it is not the correct method, it is also wrong method. I will show
Therefore, it appears after initiation of the proceedings of acquisition of state respondents, mother of the petitioner being the owner of the land in question was alive for 24 years, but she did not raise any demo.
24 years is also incorrect.
But it is, my lord, she died, my lord, in the year 30th April 1992. 30th April, annexed P3, page 25. My lord, they have annexed the document
30th April
1980, 30th April 1992. This is wrong mistake. I shall show before the Lord. But she did not raise any demo law to the steps taken by the authorities in order to conclude such proceeding upon payment of award as well as handing over possession to the required body. As per appreciation of this court, it is the mother of the petitioner who was interested person in such acquisition proceeding who would not have raised the issue which has been belatedly raised by the petitioner being the sons of the Honorable of the Dasi. Since the mother of the petitioner found that it is not required to initiate legal proceedings against such acquisition proceeding initiated by the respondent, which goes long way to show that the authorities concluded the proceedings in payment of award money to the mother of the petitioner. On analysis of the relevant facts, it appears the petitioners have tried to take advantage of the letter dated 31st October 2018 issued by the Additional District Magistrate Land Reforms and District Land and Land Reforms Officer Malda, addressed to the Block Land and Land Gajol, Malda, relating to the recording of the Irrigation and Waterways Department Government of West Bengal in the record of rights in connection with the land in question. Such issuance of letter dated 31st October 2018 cannot confer any right upon the petitioner to raise the issue of acquisition for non-payment of compensation to the mother petitioners after 42 years of initiation proceeding on issuing sort of notice under section 3(1) of the Act 1948 and 12 of 1976. On the point of delay made by the petitioners in approaching the court, reliance on the place of the judgment dated August 2009, Council versus Council and other, and Supreme Court decided upon placing reliance on another judgment of August 2007-9, Chief Judge versus Union of India. The reasonable time for approaching the court, the petition is 3 years. In view of the aforesaid discussion, this court does not find any merit in the petition and the state that is allowed. Well, and my point is this, Lord, this writ petition filed in the year 19 land acquisition case of 1976. But this writ petition filed by the writ petition of 3 writ petitioners, Lord, on 6 September 2019. When it appears from page 20 of the writ petition.
Not 18th September.
No, 6 September. Page 20 of the writ petition. When it is upon by one Gaurang Das. And kindly see the affidavit. Kindly see.
Page 30.
Thank you. That is a repetition.
Yes.
I see Gaurang Das, son of Satansa, aged about 33. He has upon my love constituted attorney. The land according to the year 1970 he was not born, my lord. He has stated true to his knowledge. My lord, there are 3 writ petitioners, but my lord, he has stated he is a constituted attorney. My lord, now I will draw your attention, my lord, page 35. That is the Ammustan now.
Yes.
I am reading it. Borabor Gauranga Das, well, who has appointed? Lichitam, next minute, fourth line, fifth line. Because Narayan, he is one of the petitioners and son of the Konoblota Das, original landing. Reading here, Sorgio Ramniran Juti, Professor, Post Amokto Nama, Potro Milan Gito, such and such, Miller, সম্পত্তি আমার মাতা কনকলতা দাসী মহাশয় সাথে স্যার তিনি 16 আনা ভোগ করলে 3 পুত্র এক কন্যাকে ওয়ারিশ রাখিয়া পরলোক গমন আমি পুত্র হিসাবে ওয়ারিশ চাকরির অংশ সাথে স্যার দেন মাইলর বর্তমানে আমার অন্যান্য অসুবিধা হয় সাথে স্যার আমি আমার বিশ্বাস করতে he has upon my lord only has given the Amuktanama. No other petitioners Milan, not Milan Kumar Putti and others, not given Amuktanama to constitute a account. They are found this certificate. Next Milan, another Amuktanama here, that annex Milan.
Gaurangodas and Nitya Mundal give this Amuktanama.
Yes, Milan.
Sorry, Bhuti has not, Vikas Naran has given this Amuktanama to Gaurang.
Petitioner now.
And Nitya Mundal also.
No Milan. Where Milan? No.
Page 35. Barabar, Gaurangodas and two Nitya Mundal.
Amuktanama আমার সমর্থন করিবার নিমিত্তে অ্যাডভোকেট
Page 35. Page 35.
Page 35.
The beginning of that.
হ্যাঁ মিলন
Barabar Sri Gaurangodas is 1. 2 is Nitya Mundal.
and Nitya Mundal is not Milan here.
Nitya Mundal is not a party.
Only Gaurangodas affirmative affidavit, page 20. I have shown before your lordship as a constituted attorney, and he has stated his age is 33 years old. And Milan, next Milan, page 41. Another Amuktanama. It has been mailed to the Joydev court. Ligitam Milan Kumar. He is not the matter constituted attorney and he is not a Joydev court.
That page.
Therefore, page matter 44. 44. Page 44.
Joydev Ghosh, Gaurangodas, Nitya Mundal.
Only Gaurangodas Maharaj stated Maharaj he is the constituted attorney and he has affirmed the petition. As it appears from page 20, Joydev Ghosh Maharaj is not there. Here. And he is not the petitioner before or the appellant before your lordship.
Vibhuti and Milan have given these two powers of attorney. Right. Who are the writ petitioners?
These petitioners, my lord, here. Milan Kumar Putti, Milan. Page 5 Milan. Milan Kumar Putti, Sonda Sarkar and Vikas Naran.
On the Sarkar also gave power of attorney by the page 44 power of attorney.
44.
Page 44. If you come to page 45, both Milan and Sonda.
The Joydev goes Milan, not to the Gaurangodas.
No. 3%. Joydev, Gauranga and Nitya Mundal.
Yes, I am wrong, Milan. I am wrong.
Therefore, Joydev had the power of attorney. One of the parties.
They have given manner to the Joydev goes Gauranga and Nitya Mundal. Yes.
So then this point you are relinquishing.
No, Milan. Not relinquishing, but I am showing before the lordship. Then, Milan, what is the case before this honorable court?
No. What is your point on this? Gaurangodas we find from the affidavit.
My lord, then it is correct.
So then you are not
No.
arguing this point.
Power attorney is my lord, it is correct for the person.
Right. So we are not recording this report.
No.
Great.
Yes, Miller, what is the case before this honorable court? Miller, the petitioner in Miller paragraph number 2 of the writ petition stated the mother of the petitioner, Miller Konokulata Dasi, was the absolute owner of 2.65 acres of CS on RS code number 16 and the LR dark number 36. That is, my lord, ROR, my lord, it appears page 20. ROR, my lord, it has been stated here. I will see, my lord, ROR. Monokolata Dashi, Rayo, Ami Ramnarayan Das.
And this is page
22.
22.
23.
23. Yes.
Not Ramnarayan Das. Monokolata Dashi is the petitioner. His name is recorded. And her husband, Ramnarayan Das. And Milord, number 36, it is correct. There is a minor Borgada, Lalu Tudu. Don't miss any month.
So what is the point? That her husband's name was Konokulata's husband's name was Das. Das may be a title.
Whatever it may be. So it is another calculation. Well, total point of land is 2.57, not 2.65. They have stated in another manner in paragraph number 8 decimal has been recorded in another person. Therefore, it is not 2.5, not 2.65. Paragraph number 8, manner they have stated the 8 decimals have been recorded in the name of the Madhav Chandra Rao. Therefore, my lord, the petition is equal to 2.57.
All right.
My lord,
Acquisition was in respect of what?
2.57 acres of land.
The acquisition was in respect of 2.57.
But the next, my lord, your lordship, regarding my lord, the date of death, my lord, page 25, my lord, they have stated in her mother died on 9th, paragraph 4, my lord, they have stated 9th October 2000. That is not right. Page 25, my lord, is correct. Page 25, my lord, the ARC certificate, my lord, working.
Yes.
Certificate that Konokulata Dasi, who is Sate Ramnarayan Biki, Bolor Sate Sir. Is for 30th April 1995.
What is the second point you are developing, Mr. Bandhavata, that Konokulata's name was recorded?
That's my own way.
No, in your own way. What is your own way? That is what we are asking. What is the point you are developing?
I might be coming with you.
We have not yet come to the point.
No. I'm showing you what.
No, you said 2.57 versus 2.67, 2.65. But the records of rights show 2.57.
2.57.
Regarding which acquisition occurred.
Yes.
So what is the discrepancy? Why are you showing these?
My lord, paragraph 9, my lord, they have stated in the 2009.
What is the point, Mr. Bandhavata? First tell
When
that.
they have come to know from the office, my lord, BLRO, the BLRO wrote additional description.
So there is no need to go into the entire document. You develop your point. You tell us your point. And
Page 26.
so what is the point first, Mr. Bandhavata?
Page 26, my lord, when the below additional district magistrate wrote a letter to the blockland and land resource officer to record the name in favor of the irrigation and out. What are those reports?
Yes. So what?
Then they came to know. And my lord, it has been recorded with the name of the irrigation and waterways department, page 29. In respect of 2.65 acres of land.
So this is not 2.57.
The 2.57 belongs to the petitioners. For mother,
Very
and the next page is made page 30. P5. That is the possession 36. You have to kindly turn to page 32 of the petitions annexure. Annexure P6.
Yes.
That is the notice under section 3A. It is form of notice under section 3A, land acquisition, address to Konokolata Dasia Lali.
Form of notice under section 5(3), not 3(a).
3 5 below.
Subsection 3 of section 5.
Yes, below. And when it has been issued and hearing was taken on under section 7. Whereas 2.6 acres of land Milord of Gajol Mouda, certain side 4th line Milord, West Bengal land acquisition at certain side, section 4 was published. Section 4 was published on 18th May 78. Milord body.
Yes.
In Calcutta Gazette on 26th October 2078. And this fee was called for Milord hearing in respect of the said land.
Yes.
They have stated, Milord, in paragraph number 12, petitioners collected the papers of the petitioner. The department filed from it appears the notice was issued to such and such in the name of the mother of the petitioners in respect of the such and such and notice of the, and in the said notice the mother of the petitioner were directed to appear before the concerned authority on 23rd October 1981 at 12 noon. The nature of her.
You are placing their case, Mr. Bandyopadhyay. What is your point?
But he has stated, my lord, whether this notice has been served or not, it is not known to the petitioner. Next paragraph.
Show that.
30. Paragraph 30. That is, it appears the notice is acquisition in respect of the petitioner was issued, but it is not known to the petitioner whether the notice was served upon the mother of the petitioner and the land remain in physical possession. How he has come by the Gorango Das upon by to my knowledge, whether notice has been served or not. Now, my lord, you are not to kindly to come to my affidavit in opposition. We have stated, my lord, in our opposition, page 55.
Yes.
Page 55, my lord.
Yes.
May I read the paragraph 4 from paragraph 4, page 55. That because dealing with the paragraph was statement in the restriction and submit the following facts which are necessary for the disposal of the restriction. 2.65 acres of land on Moja Ronga Vita, their number 84, Kutiya number 37, Ida plot number 33, Harris plot number 53, K.S. Gaju, Vishnu Malda was recorded in the latest number, along with plot number 37, Gaju. Moja and jail number 7 for the passport of state. When two Moja's land has been taken, one Ronga Vita and one of the petitioner land is in respect of Ronga Vita. Handed over the possession was for the purpose of construction of statute in connection with the systematic project. Handed over the possession requiring body assisting in the requisition and the required body taken on the position. My lord, it appears from page 59, my lord, possession certificate. Possession certificate. The accordingly calculation sheet made for the LA case number such and such acquisition given for the land in favor of Konokolata Devi, wife of Ramlal and his mother of the present petitioner number 1. Xerox copy of the calculation sheet are seen by page 60. That's another calculation sheet. And my then on 23rd August 1994, award money paid to the awardee amounting rupees, my lord, this amount is wrong. It's stated, my lord, this is my lord, 39,635 and 60%.
Which page?
My lord, I am reading from page 56. It will appear, my lord,
66.
No, no. 64. Yes,
64.
by check, it has been paid. 39,630. This amount is that is the
Why are two checks mentioned?
two check will I'm showing you. My supplementary paper they have minor damage. Two check will I'm showing you.
Both checks to heart.
Okay.
So more than 39,000 then.
More than 30.
Plus 3,000.
More. Sorry, Shakir, so I'm gonna say supplementary paper is here. First below supplementary paper book below page 11. Personal ledger.
Yes. This whose personal ledger account, Mr. Bandhu?
65. Maybe a lot of page 65.
Of the main paper book.
65 plus this supplementary paper.
Supplementary.
Supplementary.
Yes. 65.
Supplementary paper book Miller.
Office of the
Seat number, my lord.
office of the is blank. Whose office?
I don't know, my lord. It has been by the all the people. It was hard by my lord. Justice origin my lord. All the papers my lord submitted before the lord. They have taken inspection, my lord. My officer was present and his lordship recorded that.
No, but we are asking whose office is it? Who produced this personal ledger? It was an annex to the
We
appointment.
took the inspection, then we asked.
No, this was annexed by whom?
By me.
You.
Because we took the inspection, they did not annex anything. So we took the inspection, then we took the photographs. They supplied me the photographs of all the documents as per my request, and subsequently we filed this by way of supplementary.
Yes, ma'am. That is all.
So why are you showing this page 65, Mr. Bandhavate? What is that?
If I needed that is a minor, check number 35. Top minor, case number 35. What is minor?
Yes.
Check number A231583. Account number 35, personal ledger account minor. Book number 35, Konoglota Devi Ramnarayan. Amount to rupees minor paid. Initial figure. Next page, my lord, it is received by the next page, page 66. Monoglota Dati. The above signature is identified Gonjit Kumar Ghosh Advocate. Next page, page 67 million. Check number 37 million. Monoglota Devi. Amount minus 3,171.90 paid. This is the cost of malware temporary occupation or cost of. And my first one is cost of land. But a developer can with age.
Of the
Also submitted people. Mother hotel kind of a just submitted people. They got
page 8, yes.
paid it. They are digital.
Yes, please.
On 17th February 2023, the additional land acquisition officer is present in court today. He produced copy of the relevant award. Hence, the contents of the appellant that no award was ever declared is not correct. All the relevant documents were reported before the total law is on checked. Never had this is the opposition officer. Therefore, when the award has been declared and detailed in my lords,
What is the award? That is a part of the paper book.
I have shown for your lordship.
This is the final hearing. This is an identity observation that is not binding on us.
So, yes,
So we have to see the
that
award.
is true. Page 60 of the paper, supplementary paper.
Page 60.
Page 60. এটা তো মিলছে না। এইটা বেসিক ফিট of the supplementary paper. Up to years.
The calculation was at which page, Mr. Bandhotra?
এই অনুষ্ঠানে বিনোদ বক্সে
Yes, page 64 of the main paper.
What did you learn? On the supplementary paper?
No, the main paper.
Calculation sheet.
Calculation sheet we have got.
Award.
Where is the award?
Page 62 million of the financial order.
62.
Supplementary paper.
Yes. Wait.
May I read below?
Let's come to that. Yes.
And award rupees such and such, 60 such and such, only towards cost of the acquisition of apparatus for construction of stackyard rentals. So that is the Krishna Garage project is signed, declared, and filed today. Further, I am an award of such and such toward cost of requisition period of the above land is signed and declared and filed today. Payment of rupees such and such by check will be paid from the GDO office, Gajul. Therefore, it has been reached. Next page is the calculation. Next page. And you are while showing before another thing, the possession was handed over and taken over.
Possession certificate is showed at page 59.
The order is there. The order. order. 57 months. This 57 or supplementary table. And whereas my opinion suggests that third paragraph below, second paragraph, and whereas is hereby notification number certain 9663 certain part 1 26 December certain authorized in exercise of the subsection 1 of section 3 of the West Bengal Land Acquisition and Acquisition Act certain Requisition Act. Now therefore in exercise of power under section 1 of section 3 of the West Bengal Land Acquisition Act 1948, read with the authority is vested the land aforesaid, I do hereby distribution certain Miller, next Miller, page 58, then Miller, page 59. 59. Then next page 59. Order dated 12th August 1976. Requisition order has been signed. Start the copies of the order upon the interested person. Sri S.R. Rudra KGO is authorized such and such take over and make over possession RV such and such. Next minute, next column done. Number such and such, date such and such. Next at the bottom minute, possession for area such and such of the land taken over and made over to the until. The order has been passed for such therefore, it is crystal clear what the land has been and they have taken a further point. They will in supplementary liquidity why when trade because of Ramnar and Dr. The protocol of the take protocol of the deed. There protocol of the deed and protocol of the nothing for the same part. But in the ground law, they have two protocols. And when these ones have not been taken, the repetition also. Now they have come, the hard money has not been declared in the time. When it is nowhere in the repetition, when they have not stated, not in the ground at all.
What was the ground then? These documents were not before then.
No, yes. But it has been happened by one Gaurango Das stating here after 42 years Miller of the acquisition proceedings, during the lifetime of the woman of the Honorable Devi, when she has not challenged these acquisition proceedings, this is incorrect. It is not in the proceedings have been taken. Ground may be whether they will continue. And one affidavit we have also used the supplementary affidavit in connection with a can. Yes. Can. Whether it is supplementary affidavit, page 45. Now in the administrative manner, they have taken the new tax manner ground. That is not in the distribution. Well, may I read the what is it in opposition of the supplementary affidavit?
For what purpose? We said.
It is stated that the land manor now resulting manor is taken by the government by construction of a bus stand.
Of a?
Bus stand. And
Which
they
paragraph
paid for
of
the-
which paragraph of affidavit?
Can minor 35. Page 35, can minor supplementary. The supplementary paper.
Supplementary paper is 35.
Yes, certificate, that is the CAN application, they have 5 million.
Yes. Where is your position? Where you have stated what?
Our competition measure page 45, start from 44, 45, 43 million starts.
This is your opposition to the CAN.
CAN.
You say that you have stated in the opposition to the supplementary affidavit.
Supplementary affidavit used in this connection.
No, where have you stated that bus stand is being? You
Yes.
said that you have stated that in opposition to supplementary affidavit.
Yes,
But now you are showing opposition to the CAN.
CAN. There, my lord, there is some far minor transaction.
So Bandhavate, you told us that you have stated that the land is being used for construction of
No, my lord, it has been, my lord, now.
allocated for construction of a bus stand.
Taken from me.
You have stated that where? In your opposition to what? Yes, page 53 of the supplementary.
My lord, in page 38, my lord, they have stated that the appellate, their supplementary affidavit, my lord, they can. That the appellate petitioner state that the aforesaid appeal is pending here in the honorable court, but in the meantime, district magistrate Malda, subdivisional officer Malda, development officer Gadoi, district magistrate Gadoi police station and others visited the aforesaid land of the petitioner on 17 July 2024, and they declared that a bus stand to be set up on the aforesaid plot of land, and petitioner threatening of the petitioner and threatening that they would take possession of the land very soon to setting up a bus stand. And therefore they prayed for
Page 53 have stated in detail. Page 53 of the supplementary.
Yes, Miller, so paragraph 50. That with regard to the statement, paragraph number.
You have read that paragraph. So, lying vacant and free from all encumbrances, proposed to construct a bus stand.
Minor, this case was dismissed minor between default. And in that time, minor, there was no minor dictating order, nothing minor, the other matter was dismissed. On that point of time, minor, this is a question.
This
Now, it has been-
appeal was dismissed or the writ petition.
It is not because of you. That's the possibility for it. That's miscellaneous.
So you said there was an award which has been produced as well as possession certificate, compensation paid, everything done. So there is a scope of challenge. And Gaurang, who affirmed the affidavit of the writ petition, was 33 years old. At that point, he was not born at the relevant point of time. And he said directly, true to my knowledge. Therefore,
And now it has been the State Department of minor and transfer minor before the.
that is different.
And then may I replace the minor?
If the acquisition goes, then the entire things go.
Now may I finish the minor paragraph 15 and 16?
15 you have read.
16. Because it was. ঘটনাটা আমরা দুটা ডিপার্টমেন্টের ট্রান্সফার করছি।
Yes.
All right, Madam. Now the government is decided to transfer that department for sponsors.
Transfer has not been effected.
Not yet because there was no case is pending for it.
All right. Yes. All these documents are before the court. Award, possession certificate, check, and your mother received the compensation.
It was not equal to that.
Put it before the court.
But this is a no, Madam, what are the documents
The
that
documents are before us. We cannot shut our eyes to those.
provided?
And those you did not take any objection because just management division which observed that there is an award. There is an award,
No.
page 8 of supplementary agreement.
According to their statement, there was an award.
No,
Now,
Justice Banerjee's division bench recorded there is an award. Your point that there is no award is not correct. You have not challenged that order. Records are produced before the court.
Record was produced before your lordship, but no award copy of the award was shown to the produced before this court. With authority, I am saying before your lordship.
No, they have, it is there in the supplementary paper.
Supplementary paper. No, my lord, kindly see the order page 8. Justice Banerjee's order.
Yes.
The additional land use officer is present in court today. He has produced a copy of the relevant award. Hence, the contention of the appellant that no award was ever declared is not correct. Mr. Pan Lamin, advocate appealing for the appellant, however, says that his client never received any compensation or notice of the award as contained in the secretary of the appellant. Let this matter once again as well circumstances of the additional recovery officers shall produce the notice of the award if they can trace in the some of the records. This was never been put in. Now, moreover, my lord, what I
Page 62 of the supplementary paper.
62.
That is just now read by Mr. Pandora.
This is not the notice. This is not the notice.
This is the award. You said there was no award, it was only a
So this as I shown to your lordship, the award should be in form 13. This is an order for award. Kindly see, my lord. An award, this cannot be said to be an award. Award should be in form 13, I shown to your lordship.
Yes.
And this should be approved. Kindly see, my lord, that next page, my lord, I have typed copy. An award of such and such towards the cost of acquisition of land, construction of stockyards, and the discovery amounting to rupees cost of acquisition, and payment up to rupees in cash above together will be paid by BDO to the office. This is not award. This is an order of the collector. Award should be in the form of 13. In the form 13, it should be declared. It has to be declared. From this has not it does not appear that this has been declared. Declaration should be made after preparation the award after apportionment in the form of 13. Then notice for compensation. Now, madam, my respectful submission before your lordship, I have categorically said that non-service of the notice under section 3(1) vitiates everything.
Your mother was alive, she did not take the point even after taking the compensation.
I have not received compensation. That is exactly what I am saying.
The produced
All the
documents should check.
replicated false. That is not my signature. Kindly see.
You, how can you know it cannot be your signature, your mother's signature?
Madam,
She did not challenge you
because
like
personal ledger account cannot be taken into consideration for payment of compensation money. Since why I am saying this, my lord, kindly পেজটা দেখো যেখানে আমাদের সিমিলার টাইপের মামলায় যে কিভাবে পেমেন্ট করতে হয় page 14. Kindly come to page 14. What should be the mode of payment? Kindly see. The personal account they are saying that it cannot be paid like this. It has to be paid in yes. Page one I have managed page 14. In this form, the payment has to be made. And there is no denial to this. These are the form which has to be maintained. In a personal ledger account, I have come across for the first time that such in this fashion payment can be made. It's a personal ledger account. Kindly similar to the this amount credited on whose behalf? Kindly see. On the State Bank of India Treasury of Secretary Office, such and such.
what is that page?
That page 9.
Yes.
It's a personal ledger account maintained for themselves only. An account of blank. Initial drawing officer, initial of check writer, unheard of. In this fashion, my lord, this can be paid. This can be paid only in Form 13A. That too, my lord, the mode of payment should be under section 31 and 32. Section 31 of the Act 1 of 1894. And why I am saying this, if you are kindly come to section kindly turn to me, Lord, for my satisfaction, Lord, kindly at the cost of deputation, Lord, kindly excuse me. My Lord, the section 7 deals with the compensation of Act 2, F46 page.
Yes.
Can you see the component which is required to be incorporated in the award? Section 7 is clear. Section 23 1A and next to, my Lord, kindly see subsection 2A. When the compensation has been determined under subsection 1, the collector shall make an award in accordance with the principle set out in section 11 of the Land Acquisition Act 1894, and the amount referred to in subsection 1 section of that act shall also include in the award. But why I shown to this page 14 to your lordship? Once again, kindly turn to the section 40, page 14. Your lordship will find everything has been indicated. What is the land value? So that with the reference code, I can take this point that look, this is the land value. I am agreed. This is the solution. I am agreed. Reference code, I can take this plea. But from the ledger account, one cannot make any reference. Where is the indication? This is an award.
But Mr. Pan, if that award, that whatever they are saying to be the award, if you had agreed, you could have taken out a challenge under section 8. Your mother could have.
But provided there is an award, then only section. Kindly see when section 8 can be made. Kindly have a look at the signal. If that is not award, section 8, kindly see section 8. Where any person interested being aggrieved by an award made under subsection 2 of section 7. My respectful submission before your lordship is there is no award under subsection 2 of section 7.
Now, 7A, Mr. Pan,
No.
does it prescribe the format?
Yes.
Does it say it has to be in a particular format?
Yes, because kindly see,
Let us
the
come to
format is my lord 7A.
Format 7A first.
Yes, one.
The parent section has to refer to a format.
Yes,
which then is provided in the rules.
but the rule is silent so far section 7 is concerned.
Section 7, where has it been stated that it has to be in a particular format?
Yes, can you see? Subsection 2.
Section 7A. That is that
No,
was the award taken.
7A provides for this was incorporated subsequent to the when the act was restricted to 31st March 1997 in the year 1994.
Yes.
Then legislature thought, what is the fate? If award expired, act expired, then award not passed. That is the reason matter 7A was incorporated on 8th of October 1996 with retrospective effect.
Yes.
To indicate the fate of the proceeding initiated under the act.
So what we find the format of the award. You are saying it has to be in form 13 or 18.
Well, that is they are using because
I get it in the statute.
I must be candid because why I am saying this.
If the statute does not make it mandatory, then it can be in any format. Where does the statute say that it has to be in a particular form? And if so, what is the form? Show us from the statute.
May I request your Lordship, may I come back next week?
No, no, we complete arguments.
So far the rules is concerned, I have and
There is nothing in the rules. We have seen.
nothing in the rules.
If there is nothing in the rules, how can you
But
insist?
let me submit, but as a personal leisure, it's a
No, no, that is a good argument.
Yes.
We understand that.
yes. And moreover, my lord, I've been instructed to submit before Lordship. The check number cannot be like this. A. This is a treasury deposit. I am the every right to say. Why you are saying that I am who am I to say? I have to point out the defect. It's a sent to the treasury office in the name of the Paramnath Dasi. Might have, at best. But it cannot be said that payment has been made through by this document. And moreover, one more argument has been advanced before your Lordship. I like to reply to that. That they have said that 5(3) notice was served. Subsection. Well, firstly, that is not my case. What I have said that I collected a copy of the notice of subsection 3 of section 5 from the office of the respondent. And I presume that such notice was ever been served upon my mother. And this statement has been dealt with in the opposition without denying this fact, without denying my statement. Kindly turn to my lord, the page where I have said paragraph 11, page 11, page 11, paragraph 2, that the petitioner stated that your petitioner collected the papers from the concerned department, wherefrom it also appeared the notice was issued by the collector in the name of the mother of the petitioner in respect of the land measuring such and such. And in the said notice, mother of the petitioner directed to appear before the concerned authority on such and such to state the nature and interest of the land and particulars of a claim of compensation. Your petitioner said that he filed the said notice of acquisition in respect of the land, the physical person such and such. Well, collected from the department. Now this has been dealt with in their opposition at page number.
Yes. Even if they don't deny that you have collected it from the office, that does not mean they automatically admit that there was no notice. Might have collected from the office, but still then there might have been a valid notice because you are the heirs of the original land user.
Only thing is what I'm trying to impress upon your
You might have obtained this from the office very well, and then they might have
what
checked.
I'm trying to impress upon your lordship, my lord, from where my whole intention is this, my lord. Why I came to before this court, at what stage and why? Because my disposition was written on the ground of delay. So, my lord, at any material point of time, I was not aware about all these facts. Only thing I want to try to impress your lordship, when the record of rights stands in the name of my mother till 2019, when this was changed into the name of the irrigation department, then I raised my protest. Then I came to this court. When I came to this court, then these are the documents that have been produced before this court. The award has been declared as the present. Why I am telling all this, that there is no delay on my part in approaching the court, or my mother did not approach this court challenging all these things, because there is hardly any scope for challenging the conduct of the respondent, because my mother was never been served with any kind of notice, including the award.
So, want to add something, or that is all? So, hearing is concluded. The matter is reserved for judge. Thank you.
Item number 6.
Number 6, the your lordship.
Yes.
On the last occasion, the Advocate General was making his submissions. He is on his legs indeed, your lordship. He has requested a week's time only.
Part heard matter.
On the last occasion, my lord, they were not there, my lord. Lordship,
No,
the
it was on the
first
last
paragraph.
vacation.
Maybe.
Your lordship, a week's time or final
No,
request.
no, no.
Your lordship may fix it on any day, your lordship.
No.
The learned Advocate General was making his submissions. He shall conclude it on the next day, your lordship.
No, we are passing over for 15 minutes. If you can come, all right, then we'll close the argument. Sir.
Your lordship will kindly, your lordship, for a last chance, your lordship kindly grants the last chance.
Not in part heard. Not in part.
Your lordship, the argument was being conducted by
Yes, see,
learned
take
Advocate
instruction
General.
from
Your
him,
lordship,
whatever.
the argument had been initiated, your lordship, the last
Understood,
chance.
but
He's on his legs, your lordship.
no, part heard matters we cannot repeatedly go on adjourning and because
Last occasion, your lordship, that was adjourned.
no.
Yeah.
No, we are passing it out for 15 minutes. It can come.
Item number 7.
Yes. Already favored by some.
Yes.
Therefore, also confident university of trading half of the of
Yes, yes.
You also want to use also rely on judgment. That's only.
Yes.
That was the observation of the court that before they rely on judgment, you will see the title. Now, that's the yeah. That's my
Yes. We shall not wait for him. What are the judgments you want to say? Would you like to rely on his judgments, Mr. Bhattacharya?
Yes.
What are the judgments? Start citing. Let him come in the meantime. Yes, Mr. Thor, what are the judgments you would be citing?
last occasions. I got stuck regarding the manual. The action was saved as per the manual. But today, I would like to show the history of ferries being settled by the district authority or state authority. First, I would like to show one judgment, that is 1973 SCC 109. This was from the same district. 1970 volume 3 SCC page 109. There was a suit from the Zamindari. This state authority has resumed the 11 ferries from the Zamindar. And regarding that, there was a suit. In that suit, and subsequent High Court's order and thereafter to the Supreme Court. The history has been written that under Regulation 1 1793 onwards, these ferries being settled and the law was governed. Kindly come to para 2. There is not much dispute about the facts which gave rise to the claim by Regulation 1 of 1793 called the Bengal Permanent Settlement Regulation 1793. The Governor General in Council gave legislative recognition to the proclamation previously addressed to the zamindars, independent talukdars, and other actual proprietors of land paying revenue to government in the province of Bengal. Then Malad kindly come to the same paragraph at the after few lines between the years. Malad has got it. Same paragraph. Between the years 1857 and 1860, the ferries were in exercise of the power conferred by Regulation 6 of 1819, declared public ferries by the government of Bengal, and the then zamindar was paid a compensation of rupees such and such, being 10 times the income received from the ferries in the year next. After resumption of the ferries by the government ferries in the year next, such and such. Now, I kindly turn to the next page, page 5. Ferry means the right to keep a boat such and such, then of ferrying passengers to charge tolls for so doing, and to prevent other persons from setting up another ferry so near and in such a state of facts as to diminish the custom. Now, I kindly turn to the next page. This was the Shariati interests has been also been mentioned. The one of the first rules which the government promulgated in 1772 was to suppress
Shariati interest.
Yes, this is shire duties. Malad has got it.
Shariati is different from shire.
Yes, Shariati interest has been originated from the word shire. Duties levied in. Malad, I'll show that why this was a case where on 2 counts the compensation was asked for by the zamindar. One is right to ferry, another one is in lieu of the ferry charges, what was the compensation they used to get from the transporters. So on 2 counts, and during that, court has held, yes, the zamindar is entitled to get from the government on 2 counts. While doing so, this was the discussions was made from settlement 1 till settlement 6. Now, after this, why I am showing this? After this, six settlement. There was G manual. So first regulation 1, then 2 regulation 6, then G manual came into force. I have only
You could have given the cover page also. Always when you
yes,
you have
next from next one onwards, I have the cover page.
What is this?
This is G manual.
You don't have the cover page. Do you have the original? How do you know what this is? From the middle of it, you should not say. G means government or what?
Yes.
You need to see the cover page at least. We have. I have no idea of the G man.
Right. The reference is made in the next regulation. From that, I could show. Well, G manual. Kindly hear me, my lord, I'll provide the
Cover page.
cover page
Yes.
also. Register 6 at the bottom.
Yes.
My lord has got it. Only para 31. Register 6 is a register of miscellaneous demands of a recurring nature, leases of grazing rights, forest produce, fees for foreshore lands and jetties, and miscellaneous demands which, though not of a regularly recurring nature, are not paid in one lump sum. For example, salami, for which installments have been allowed, lease of carts or ferries, only here ferries, which are settled annually, should also be entered. One has got it. So after this regulations was over, after West Bengal Estate Acquisition Act has come into force, through this G manual, ferries were to be settled under this G manual. Now, I kindly turn to the next page. Form of lease on top for the settlement of jol courts in navigable rivers. What has got it? Then at the bottom 8, that the lessee shall have no right to ferries on the river, nor shall he have any rights whatsoever to the subsoil of the jol court or any minerals therein. Now, I'll take Manor to the next manual that was of 1977. Here I have the cover. And in that manual, my lord, will find that G manual has been mentioned.
Yes.
Now, my lord, kindly come to the second page, that ferries and futagaris B on the right hand side at page 61 at the bottom, 226. My lord has got it. Ferry includes a bridge of boats, pontoons or rafts, a swing bridge, a flying bridge, a temporary bridge, and a landing stage. Then ferries which have been declared as public ferries under the Bengal Ferries Act 1885 shall be exclusively under the control of the district magistrate, subject to the direction of the commissioner, and will be governed by the provisions of the said act. Public ferries are under the administrative control of the PWD, Public Works Department. Then ferries other than those declared as public ferries, namely those vested in the state under the West Bengal Estate Acquisition Act, as also the old Khashmohol ferries, will be governed by the following rules. Then settlement of ferries 228 should be made by public auction, subject to the conditions that the collector will not be bound to accept the highest offer. In rejecting the highest offer, the collector should record in writing reasons for doing so. Auction should be held at least 3 months before the date from which the settlement is to take effect. Then, in cases where the highest bids such and such formalities, then my kindly come to
But does this manual derive authority from? It says published under the authority of the Board of Revenue. Any statute gives confers such power.
land reform.
Yes.
Then 231, the collectors of the districts are empowered to accord sanction to the settlement of ferries with a revenue not exceeding rupees 2,500 in each case. The commissioners of divisions are empowered to confirm settlement of ferries with a revenue not exceeding rupees 20,000 in each case. So there was a pecuniary jurisdiction also. Now, now, has relied on 2 government orders. One is 79, another one is 87. But in between these two government orders, there were clarificatory government orders also, which were not being placed. Rather, even I was not aware. Perhaps Mr. Shahara was also not aware. 7th March. 7th. Now, this 7th March 1979 was relied. Yes. In accordance with the decisions taken by the Cabinet Subcommittee or Panchayat institutions for the transfer of khash or vested tanks, ghats, bazars, and ferries to the Panchayat bodies for their control and management. It has been decided by the Board of Revenue that the following steps should be taken for the quick implementation of the decisions. Then, Malad, kindly come to Roman. As soon as the lists are prepared, such khash or vested tanks should be formally handed over to the respective Gram Panchayats on and from the 1st Boishak, 1386 BS. Likewise, lists of khash or vested tanks remaining unsettled may be prepared and such tanks handed over to the Gram Panchayats immediately. Separate lists of khash or vested tanks in respect of which lease or settlement would expire on subsequent years should be prepared, immediately indicating against each the date on which the term expires. Now, Mara, kindly turn to the next page, that 8, 9 and 10 relevant clauses. When it is by the Panchayat, when it is by the Panchayat Samiti, when it is by the Jila Parishad. Now, the next government order on this field by the Board of Revenue, same Board of Revenue, and mentioning about this geo, previous geo. Dated 21st May 1979. Now, after subject, in board's memo number 2634, Mana, kindly cross-check the previous memo. GEM dated 7th March 79. Instructions were issued for making over khash or vested tanks and ferries to the Panchayat institutions in phases in accordance with the decision of the Cabinet Subcommittee or Panchayat institutions. It is clarified for his information that Sariyati interests such as khash or vested water areas, ghats, bazaars, ferries, etc., which are state government's property, will not vest in the panchayats. With the making over of such properties to the panchayat institutions, the said Sariyati interests are being handed over to the panchayat only for the management and control by them. The properties will thus continue to be the properties of the LU&R and L&LR department / Boards of Revenue, West Bengal. Now it is Land and Land Reforms Department and Refugee Rehabilitation Department. It may also be noted that if and when government would require any such property for any purpose, it would be free to resume possession without payment of compensation to either the panchayat institutions or the lessees or licensees. Since the panchayats would hold the properties only for the management and control, they will have no right to dispose of or alienate any such property in any manner except by way of short-term lease and license, subject to the right of the LU. I am emphasizing on that, subject to the right. Why I am emphasizing this, subject to the right of LU and Land Reforms Department, is a kind of a limitation on the Panchayat authority or Panchayat Samiti or
right to resume.
Yes, subject to right to the right of the LU and R and LR Department of Revenue to resume.
So this is subject to right to resume, but the
Yes.
panchayats will give short-term lease and license.
Yes, till
Resumed, unless
resume. Yes. Now kindly turn to the next page.
Further, since the properties would continue to be the properties of the LU and R and LR Department, Board of Revenue, provisions of the GE manual would be applicable with such modification or circulars as may be issued from time to time, for the purpose of leasing out those properties under the Panchayat. I'm also emphasizing on this. Circulars as may be issued from time to time. So till 79, May 79, there was a clarificatory geo
But still it says,
explaining.
for the
Yes.
purpose of leasing out
Yes.
properties under the contract.
Yes, yes. Now let kindly come to next geo, that is of 1980. This is again by the Board of Revenue.
Yes.
3. Now kindly come at the bottom 3 clause. The ferries which have been declared as public ferries under the Bengal Ferries Act 1885 should remain exclusively under the control of the district magistrate as provided in Rule 227 of the Land Management Manual unless otherwise decided by the administrative department.
It was previously also under the control of the district magistrate. But the right of grant of short-term leases or licenses
Was given for the time being to the Panchayat. For the time being.
that is not mentioned anywhere.
Well, as the language is subject to number 1 and
There are
any future rules or circulars.
three strata. One is that those departments would be the owner and they can resume the property at any point of time. Second layer is district magistrate would have control over these ferries, the operation of the ferries and everything. Third is panchayats can give short-term leases or licenses. So this little dispute between you now is regarding this grant of ferry only,
Yes.
grant of license only.
At the cost of repetition, may I say, my lord, in previous 279 geos, 1979 geos, where it states with such modification or circulars as may be issued from time to time for the party.
Yes, yes.
Yes. Subject to issuance of further circulars or modifications. Now, if I able to show that modifications has been made by issuance of different circulars,
Taking away the power of the panchayat
Yes.
to grant this.
absolutely. Now, yes, I'll take your lordship to this. 22nd June 1987, Maharaj, the last government notification. Kindly the preamble. In exercise of the power conferred by Section 13 of the West Bengal State Acquisition Act 1953, West Bengal Act 1 of 1954, read with Rule 12 of the West Bengal Estate Acquisition Rules 1954, the governor has been pleased to order as follows. So all the khash and vested tanks and ferries belonging to the state shall subject to the rules for the time being in force and subject to the directions issued or may be issued by the government from time to time, be managed by the Gram Panchayats and under whose respective jurisdictions the said tanks and ferries are located. Again, it is saying, yes, Panchayat can, till government comes with a new circular or notification. In case a khash or vested tank or ferry falls under the jurisdiction of more than such and such, that Gram Panchayat, then Panchayat Samiti, then Jila Parishad. Now, my learned senior friend wants me to place para 2 and 3 also of that. Yes.
Two we were reading.
Yes. Not kindly read. The cash and vested tanks and ferries which are under valid lease or license granted by the collector shall be managed by the Gram Panchayats, Panchayat Samitis or
This
Jila
sort of
Parishad.
reverses the role. Sort of reverses the role.
Yes.
License granted by collectors shall be managed by Gram Panchayat.
Number
Yes.
the cash and vested tank and fisheries which were handed over by the collectors to the Gram Panchayats, Panchayat Samitis or Jila Parishads as the case may be in pursuance of the memo number such and such of 79 of the Board of Revenue Government of West Bengal shall be deemed to have been always managed and shall continue to be managed by the respective Panchayats, Panchayat Samitis and Jila Parishads on and from the date on which the said tanks and ferries were handed over to them by collectors. I say those granting.
This is the last circular.
That is this 87 one is the last circular. Thereafter,
What can happen thereafter? What can happen after the last?
Yes. Two thousand one. I'll have to show what is the present circulars in place. In exercise of the power conferred by Section 60 of the West Bengal Land Reforms Act 1955, the Governor is pleased hereby to make, after previous publication as required by subsection 1 of the said section, the following amendments in the West Bengal Land and Land Reforms Manual 1991 as subsequently amended. Then, the relevant portion will be in the next page. (266). Land and interests belonging to or at the disposal of the state government includes the following: tank fishery, riverine fishery, following river, hard bazar, ferries, tolls and other Sariati and category interests. Then, my lord, kindly, I am skipping over B, C, and D. These all are, some of them are Sariati interest, the right to have the fruit, right to catch fish. Those have been mentioned. Then, my lord, query. Then, my lord, next one. Management of ferries, fisheries, each with water area up to 5 acres, tanks each with water area up to 5 acres, and other category interests have been transferred to panchayats by an order of the Board of Revenue West Bengal with the following exceptions. Then, Manar, kindly turn to 5, Roman 5. Ferries declared as public ferries under Bengal Ferries Act 1885 and now, Manar. My learned senior friend wants me to place the 6th as well, where the panchayat cannot conveniently take over management of the same.
6.
Yes, means that Roman 6 of that 266.
Achha.
Now, Manar, kindly turn to the next page. 20. Manar, on the right hand side. No, that's not it. That. Next statement. In rule
20.
Yes. Photo portion page is there.
894.
Yes. 894.
Yes.
In Rule 281A, for clause 2, substitute the following. Ferries should be settled by the district land and land reforms officer by public auction to be held at least 3 months before the date from which the settlement is to have effect. Public auction shall remain restricted among cooperative societies and partnership firms as conceived in the 266A. The previous amendment I have shown, now 281. This was the 10th December 2001. So kindly note it, 10th December 2001. Then the next one, 2016. Now these all of these are through manual. This is 25th February 2016. The governor is pleased to hereby to make with immediate effect the following amendments in the West Bengal Land and Land Reforms Manual 91 as subsequently amended hereinafter referred to as the manual. Then 266, handing over to panchayat institutions land and interest belonging to or at the disposal of the state government includes the following. Then tank, fisheries, such and such, hard bazaar, ferries, tolls and other Shariati interests. Then my lord, kindly turn to the next page. 5 ferries declared as public ferries under the Bengal Ferries Act 1885 as subsequently amended. So total control of Bengal Ferries Act, those who are public ferries, now is on the district magistrate.
But the right to issue license is still there. It has not been taken away.
All the previous notifications by which panchayat was given the power to control and manage, and in that notifications or clarification subsequent to that, those notifications, clarificatory notifications.
In one of those, we saw that yes, management will not be with the panchayats, but they will be entitled to issue short-term leases or licenses.
Yes, and in respect of the public ferries, the entire control and management would be on the part of the district magistrate. If it is a public ferry.
This is a public ferry.
Yes, this is a public ferry. For that, I'll have to show this, that whether this is a public ferry or not. So they admit that. Now, kindly. This is a communications dated 19th December 2025 between the additional district magistrate and joint director of the land records and survey. Kindly turn to page 6 at the bottom. Some queries were made, and to that query,
Page 6 of 7.
Page 6. Yes. Last paragraph. In reply to point number 2 of your good office memo, it may be inferred that the instant ferryghat, namely Nakelbari ferryghat, is a public ferry based on the facts that it is a ferry on the bank of river Ganga, Bhagirathi and RTO Murshidabad is maintaining a report of information regarding jetties and ferry service report, which includes the instant ferry ghat, which also establishes the fact that it is a public ferry ghat and managed by the Beldanga Panchayat 2 Samiti, which is also a government entity, not a non-government entity or private organization. So it may be concluded that the said Nakelbari ferry ghat is a public ferry ghat. Here public means ferries which are belonging to or at the disposal of the state government, that is government ferries, as per West Bengal Land and Land Reforms Manual for rule number 266. In next page, Manoj, in reply to point number 3 of your good office memo, it is stated that this office at present do not have any documents which establishes the fact that the said ferry ghat had ever been handed over to the to the Beldanga Panchayat Samiti or not. While doing research, I got to know a new act, that National Waterways Act of 2016. It has been declared as like NH, like state highway. There was a declaration in this act of 2016, repealing all previous acts, 82 and other acts. This 2016 act says, and this particular area is coming under National Waterway 1, and that is going to kindly come to the page, after page, at page 4. First one, National Waterway 1.
Yes.
Last 3-4 lines, Rasalpur River, through River Ganga, Lock Canal and Feeder Canal at Farakka, River Bhagirathi and River Hooghly. Why I intend, by relying on this, what I am intending to show, that if it is a national declared by under National Waterways Act, then this sort of settlement cannot be made by any parastatals of the state. It has to be done by the district magistrate. Considering the gravity. Then one last occasion, perhaps I'll take few minutes. Last occasion, I have perhaps given 1993 notification by which the 1991 manual was ratified, land management manual.
Yes.
And Manoj was that 91 manual, and you got it ratified in the year 1993.
Yes, this has been given.
Yes.
What it is.
So, Manoj, if it is a public ferries, then Manoj, control would be, management and control would be any day taken by the district management if that expiry had taken place. In respect of this particular ferry, the period has expired. That's why and regarding the discrimination, allegation of discrimination by Mr. Shaharai, that why only this, regarding that, well, all are in the pipeline. Whichever would be expiring, the district magistrate will pass a notification inviting the tender in respect of those. And one of the other judgments, one of I wanted to rely on last occasion, I could not. That is one of the notification is under 281. Notification is under 281 of the Land Management Manual. Hence, the reed court does not have the jurisdiction to go into this issue because the court of first instance would have been the Honorable LRTT, Land and Land Reforms Tribunal. For that, I'd be relying this L. Chandrakumar judgment, that is 1997, 3 SCC, page 261. 93 and 97, para and 99. And the next judgment is 2005, volume 10 SCC, page 110, that is State of West Bengal, Ashish Kumar Rai and others. Para 1, 9, 9 to 16 and 19 and 24 to 33. 1, 9. Relying on L. Chandrakumar, the court of first instance would be the LRT. And the last judgment I wanted to show, this is a taste kind of a thing. Another Jiaganj, Azimganj, Boatman Ferryghat came before this court. Regarding issue was different, but the tender process, challenging the tender process, they went before the LRTT first, and then they came to touching the LRTT. They have come before this court to show that just only I am relying on this. That no division. Since that was a tender process under 281 of Roman 3 as per rule, that's all. Yes, next after one. So
Again?
it is not for us.
So you completed both of you with the written of arguments also. In a nutshell, your major arguments you have taken on this.
Possibly, is what is submission. So for the leasing out of the headings by the Panchayat Shamitis is not raising any questions. It is maintaining control. None of the circulars, I shall argue, none of the circulars says that it should be taken out. So for the leasing out is concerned. I'm sorry, regarding other aspect, I forgot to rely on this. That is 2004 4 SCC, page 460, on the principle that subject to means it's always on the authority. They can, with a limitation, they can come, kindly come to paragraph 19. This judgment has relied Ashok Leland judgment, and subject to is an expression whereby limitation is expressed. The order is conclusive for all purposes, and this court further noticed the dictionary meaning of subject to stating. Furthermore, the expression subject to must be given effect to, and then Black's Law Dictionary has been quoted, and that was as under liable, subordinate, subservient, inferior, obedient to government, or affected by, provided that provided answer. So I wanted to say that Board of Revenue has never given the Panchayat authority an absolute right. So whenever the government has decided, made a policy decision, changed 281, 3 has come into the statute book in the manual. Since then, the public ferries should be controlled by the district magistrate. I'm deeply aware.
Third learned senior counsel appearing for the state. Question on the period of learned senior counsel appearing for the appearance, comma.
May both joint pair. Notes of submission on the place.
Yes.
Can it be Thursday week?
Yes. Comma. Let the matter stand over till January 22, 2026 for rejoinder arguments by the appellants and filing of written notes of arguments by learned counsel for both the parties.
Okay.
Thank you.
I'm deeply aware.
Thanks. You will pass over.
Item number 6.
Not yet there. Yes,
These are his legs actually conducting a matter. Another court, your lordship, his clerk and junior deputies. Anyway, if your lordship. These is here, give a last chance or a check.
check the order 6. We find from the records that on December 23, 2025, although the respondents were represented by counsel, none had appeared for the appellants, due to which the matter had to be adjourned till after the then upcoming Christmas vacation. Even today, at the time of call, an adjournment is sought on behalf of the appellants, as a last chance to the appellants to conclude their arguments, let the matter stand adjourned till January 15, 2026. It is made clear that in the event the appellants do not resume arguments and conclude the same, do not resume arguments on the same date, the arguments of the appellants may be closed and the respondents may be invited to make their submissions. Use this with Mr. Datta. Yes.
Item number 8 is 9.
Yes, Mr. Singh. Yes. Yes.
And kindly first matter I have received the EP because it is very important.
Yes.
I am Art Shashan Sir, Learned Counsel, being assisted by Shashan Sir, representing the litigation. Though the state of West Bengal remains unrepresented, but Mr. Deepak Mukherjee, Learned Counsel, representing the respondent is, that is the defendant. Present. The matter is now taken up for delivery of judgment. On perusal of the matters on record, including the evidence opposition has been described here. It reveals that the lead petitioner was the owner of plot number 690 of PN number Sachansas under serial number Sachansas in Moga, Ladipur, district Howrah. Mr. Bhattacharya submitted that the Calcutta telephones being the requiring body requisitioned 46 decimals of the same clause, and accordingly it was acquired under LAK's number 15 of 1987, initiated under Act 2 of 1948 on 6 April 1988. Admittedly, position of the said land was taken by the LA collector. While no admittedly position was
Yes. Admittedly position.
admittedly, madam, this is the kind of market. Admittedly, position of the said land was taken by the LA collector on the without payment of award. At that juncture, petitioner in the original site filed a requisition such which was dismissed, and since the requisition wrongly mentioned the number of times, Mr. Bhattacharya however applies the court that against the dismissal of the requisition should have proceed further. Mr. Bhattacharya further submitted that the requisitioner filed another requisition being WP number since no award was first despite submission of representation, and this court disposed of the same requisition 13th of June 1998 the direction of the concerned collector to consider the representation. In turn, LA collector, however, by indigenous letters 74 August 19 in compliance with the law, disposed of the same matter on 6 September 1990. For further reference and for convenience of discussion, the operative portion of the order LA collector is said. Considering all arguments, statement, and procedure, papers and documents of all concerned parties, petition in respect of annexure IJK, this is to be in order to order that the petitioner is entitled to get requisition compensation at the rate of 6% over the market value of the land from the date of restoration by switching over as proceedings under the Amendment Act 1996. And the requiring body is hereby ordered to state either their submission of this if they require present or initiate proposal for the requisition of the said plot in accordance with law by giving back position of the land to the by giving back and you take notice within a reasonable period after giving proper requisition completion and the players of the user stated are hereby allowed. As concerned parties are requested to take necessary measures for immediate relief, the respect of getting compensation in accordance with law. This order is declared by the understanding presence of all concerned. They are entitled to take copy of the as per the requisition. Mr. Satan's further submitted that despite some reasonable husband, the relief of the requisition having remained unavailable, for which again he had to move the requisition Satan's because in that occasion, this court disposed of the said requisition on 15th January 2020 directed the concerned creditor to take necessary to award money and in turn to pay the same to the requisition within the stipulated period. In the order dated 15 January 2020, it is also indicated that the Union of India for the purpose of with the acquisition of this position and the position has been taken by the elected would take necessary kind of position were taken agreement. During course of hearing, Mr. Mukherjee landed counsel in the Calcutta court that the department took position of that requisition land for taking necessary steps of their part, and the department also placed funds for the same. Mr. Bhattacharya, that is the landed counsel for representing the requisition therein, inviting attention of this court to Gazette notification dated 27th September 1993, submitted that so far as the acquisition of the plot of the land belonging to the requisition, the proceeding was started under Act 2 of 1948 for the purpose of construction of telephone exchange tower, and inviting also attention to for notice under Section 12(2) of Act 1 implement submitted of Act 1 submitted that although the award was assessed at the time of the tune of rupees 1 lakh, but it was never paid to the requisitioner despite several persuasion and submission of the representation. Mr. Mukherjee pointed out that is the telephone that in the month of November 20, there was a letter addressed to the LA collector, however, by which he had declined to accept and withdraw the amount awarded by a compensation, against which, of course, Mr. Bhattacharya reiterated that it was not accepted due to pendency of the requisition. Be that as it may, from the facts and circumstances, it appears, though the LA case number such and such was initiated under Act 2, well, first matter this kind take note of it, Act 2, by the However, for acquisition of land measuring 46 decimals appertaining to the number 690 belonging to the petition to subtract the acquisition of the requiring body of the Calcutta telephone. And in effect, it was handed over to the requiring body after taking over possession. But such proceeding could not be held to be complete since the award money was not assessed within the stipulated period. This is the bone of contention. Stipulated period after initiation of LA proceeding vis-a-vis handing over or depositing the award money. So that LA proceeding could have been deemed as complete in the law, and Section 7A of the Act 2 may be relevant to refer to justify the above observation. In further scrutiny of the materials, however, it has also been pointed out by Mr. Kajaria, that is the Learned Counsel, in the petition of theory, that the subsequent pro forma notice dated 19th of April under subsection 3A and 3B of section 9 of such and such was issued to show that the LA proceeding was converted into Act 1 of 1800 reasonably for the reasons that the proceedings of Act 2 could not be made complete in the stipulated period. The grievance is that despite order dated 6 September 1999, passed by the Calcutta and also order passed by the Sakansa Supa, the Calcutta issued de novo notice with reference to Sakansa 97 Amendment Act 1999, asking the victim to accept the payment if he was released. Challenging the said notice seeking other necessary instant has been filed, for which the Learned Counsel submitted that due to non-compliance of the entire proceeding of litigation admission of same has been lapsed by operation of law, and therefore the order should be passed either to restore the land in favor of the litigation or alternatively to invoke the new provision of Right to Fair Compensation Act 1935. It has not gone out to notice that negating the relief under such new act already there is a judgment of the division bench of this court, which also should be taken into consideration before passing in this order. In this case, my lord, State of West Bengal versus Nirati Chatterjee, I will show this. On the basis of the requisition of land possession was handed over sometime in the year 1978 to the requiring body after publication of notice under Section 3 and the notice also published under Section 418. Here, this has happened. 93B because 418 if it was not invoked, then 493B is not here. If 418 was not invoked, 93A. Yeah. So, my lord, in that case, requiring money did not place part. So the payment of the could not be made. Say the petition was filed in the year 2040, whereas the LA case was initiated in 1976. In the fact and circumstance case, the lease was kindly see. I think the Honorable Saiki, with respect, my lord, he has misunderstood the law laid down by the judicial bench. Whether compensation could be paid under the new act. Division bench had, though the proceeding was elicited under it was initially in 1970, but since there was a delay, kindly taken, but since there was a delay or latching on the part of the writ which was pending to section 24 was made. So, Honorable Supreme Judge was of the opinion that only ratio was there, that since there was a delay, on that ground, the petition was allowed so that the affected parties or aggrieved parties can take the benefit of the provisions under 1894 Act, not 2013 Act. But this is absolutely, if I permit to use that, misconception on the ratio decided by our Honorable Division. Only the Honorable Single Judge head, since there was the delay, that was the ratio as per the Honorable Single Judge opinion, but that is not correct. The law, correct proposition of law. In case on LA case was initiated in 1987, since there was a constitution by filing litigation one after another after the representatives of 1980 till 2000. Even my lord knows that there is a Supreme Court judgment. My lord, this well-known settled principle of law by making representation one after another. This is not statute limitation, law limitation. And lastly, in the year 2001, after getting the notice to 16, therefore, the facts and the agreed by the division bench delay and that is taken note of to negate the proposed relief is not the same, similar to the present case. Therefore, the case of the defendant is distinguished. So, my lord, first, my lord, kindly take note is distinguished. Distinguished in the sense, the honorable single judge, according to my humble opinion, subject to my lord's approval, that misconstrued the ratio as laid down in the honorable division bench. Because honorable division bench, in that judgment, that once initiation was being made by the concerned authority under the Act 2, So, as per section reading of section 24 of the 2013 Act, that 2013 Act is not applicable, where position has already been taken job. But apart from that, there was a delay and lapse. There are two issues. I will show that. It has been indicated on the later case which was initiated under Act 2 of 1990 was ultimately converted Act 1 1894. Now the preamble of subsection of section 20 right to fair compensation and the Settlement Act 2013 shortly because there has the act is set out to consider as to whether the question is applicable or not. Land acquisition under Act 1, notwithstanding anything from in any case, land acquisition proceeding initiated. So the misconception is also apparent that initiation is itself incorporated in the 2013 section 24. If initiation is being made under the 1894, then the 2013 Act is applicability will arise. When no award under section 11 of the State Act has been made, then all the provisions of relating to determining compensation apply. Can you see? A. Notwithstanding anything called a subsection 1 in case of land acquisition proceeding under the land Act 1894, where an award under section has been made 5 years or more prior to compensation part of physical portion of land has not been taken, or that should be an, because the my lord knows that the my lord constitutional being judgment, my lord, I'll show my lord knows that already have gone through that, or should be read as an. Both has to be, if one is missing, then 2013 Act is also not. Even if it is initiated under Act 1. Or the compensation has not been paid, the same proceedings shall be deemed to have lapsed. Can you consider shall be deemed to have been lapsed? And when deeming provisions, according to, because I have gone through the legal judgment according to knows that the deeming provision, unless it is there in the statute, the honorable court cannot take or can use that word or put that word as deeming to have. So unless it is read in the or it is incorporated in the statute. So the court cannot say that there is a deeming provision. There is a judgment manner knows that I need to cite manner the appropriate government if so shall initiate proceeding on the afresh in the provision. However, an award has been made compensation list of the land which has not been issued according to beneficiary, then all beneficiaries under section 4 shall be entitled to one in accordance with provision of this act. Therefore, the status of the elect proceeding having been given 1894 by converting it, even if it is accepted, the requirement have deposited the assessed amount to the exchequer of the state, but still the state proceeding could not be made complete within the stipulated period Act 1 under Act 118. There can be no doubt that the operation of the state proceeding would have been deemed to have lost. Again, deeming. Thereby, the provision laid down section 24 section shall be applied. Though in the requisition main relief was sought for restoration of land, but as the court is advised that the requiring body had already handed over the requiring and requiring handed over the Calcutta was enjoy this position for inputting the infrastructure. Inputting the lead court should not pass any order given under 226, which may make for authority impossible to pursue, comply, or specifically when there is an alternative between this action. Mr. Satan justified his claims, reported in but I refrain to act on the same way the reasons assigned out. However, repression stands allowed the direction of the Satan such whose magistrate in terms of section 26 the right to fair compensation act in 2013 in respect to subject clause number 690 as the department for making the award strictly in section 25 of the said act minus 2013. So that the requisition of the sales and cost may not be compelled to come again for seeking delivery, or any court may not be compelled to record any hurt or taking note of inaction against the delinquent officer responsible of the person, since it is a long pending and legal process and such within a ordinary from So, my lord, the impugned judgment, my lord, may be based on that distinguishing feature. Here, the honorable single judge has distinguished of the Honorable Division Bench order. He was sitting single. Oh, he can distinguish, the Honorable Judge can distinguish. But whether only on the basis there is a deed. The ratio is not only the deed. Ratio was that initiation, whether section 24 is at all applicable of 2039, and another above the deed. That was the issue released before that on division. So, Manoj, the first perversity I will maybe allow to make some position that this is contrary to law. And, my lord, second, my lord, that saving it, my lord, first, my lord, allow me to formulate the law, and then, my lord, I will.
You continue after it.
Item number 8 is conflict.
I was waiting for the lordship mentioning
In the middle of a hearing.
I am. This was in respect of the list of honorable judgment Banerjee because we got
Oh, yes, what is
my lord, this is what we need to file appeal without a certified copy from an order dated 6 January. And if it's not listed or heard by a lordship, my matter will become infractuous. It's a writ petition where we've been enjoining interim order for the last.
the determination has been given to us for today only.
Lordship,
We have
that
granted you
was
the
the-
leave to file it before the regular.
Lordship, but the matter may become infractuous tomorrow. Because we've been enjoying the interim order, we've come up in appeal against the order of 6 January vacating the interim order. We wanted to argue the matter on merits.
But the other side has to be given a notice.
Lordship, we give short service, Lordship, kindly.
Leave is granted, very well, leave is granted, আজকে 4টের সময় today at 4. Please give a notice to the other side.
Great.
Yes, please.
Now I am requesting my lord to formulate the law. My lord, first,
Yes.
in the facts and circumstances of this case, the first law point is to be involved in this, in the present appeal.
Yes.
If it is not initiated under Act 1, then whether, as per provisions of Section 24, whether 2013 Act is to be applicable or not. First point, this is.
Yes.
Second point, my lord, I am making that apart from that, my lord, assuming but not admitting that it lapsed because within statutes, because of 7A of Act 2, it lapsed because within the statute, award was not passed. In that case, my lord, kindly consider one thing. Apart from that, that lapsing was done for argument's sake, but not admitted. In that scenario, whether at all 2013 Act is to be applicable. Because both the 2 points are, my lord, to be taken together. Because what I am making a humble submission that, assuming but not admitting, 401A lapsed. Whether does it mean that entire acquisition proceedings to lapse? If it is not lapsed, then under which provisions of law, in other words, in other words, which provisions of law is to be applicable to make an award and compensation? And this submission is, I am making this submission on the basis of Section 24 and the judgment of the Constitution Bench and 114 of 2013 Act. So Section 6 of General Constitution. And my lord, third point, my lord, that if the 2 division bench, the coordinate bench, delivered a judgment saying that even if 401A, the initiation was made under Act 2, and the Honorable Division Bench, both the Honorable Division Coordinate Bench held that if the Section 401A was invoked of Act 2, these land vested to the state. Apart from 7A, I am coming to that because there is larger than judgment. My lord, I will point out that is per inclusion. But in the larger bench, it has been held 9CB is not applicable. Proceeding didn't lapse. 9CA you can proceed. The larger bench even didn't say or didn't that there is no ratio that if a entire acquisition proceedings to lapse. Rather,
9(3)(b) is not applicable, but you can exercise your power under section 9(3)(a) of amended Act of Act 1. And my lord, the last and but not the least, my lord, the whether binding precedent, if my lord, there is a division between the coordinate bench judgment, and the ratio is clear. Yes, my lord can distinguish, my lord can say differently. Yes, but my lord has to it has to be placed before the larger bench. As per the ratio of the recent 2026. So
If there is already a larger bench judgment, isn't that binding on the two coordinate bench judgments?
my lord,
Isn't that doesn't that prevail over those?
that's why I am making that submission. 401A gone. Whether
Can this bench say larger bench judgment is par inferior?
no, I am not saying that. What I am saying that the division is to coordinate bench judgment, which there is there are issues which says clearly that one section 401A was being invoked, then the award and compensation amount is to be paid, is to be governed by the 1894 Act. Whether that is binding precedent or not, that my lord will decide. And even that in that case also,
Larger bench is there to the contrary.
larger bench says, my lord, what I am saying, larger bench made a categorical, larger bench didn't held that at that point of time 2013 Act has not come. So that point kept open. Whether to what extent this position, if the 401A was gone or the land was not vested, then whether because at that point of 2013 Act has not come, whether initiation, it is two different aspects, man. Whether once initiation has been made, whether the 2013 Act is to be applicable. Can you see, these are my points which I will lay out. And now, my lord, first, my lord, I do not want to, my lord, place the facts, my lord. Facts, my lord, I have my lord has got once, that is admitted fact. 401A was invoked. And my lord, position was taken over back. These are all admitted facts. These are all admitted facts. I will show that the letter of the position certificate. I can show my lord, but my lord, these are admitted facts as it appears from the order of the Honorable Singh. Well, now my lord, kindly consider state name, my lord. This is a very interesting point. First, my lord, I am placing my lord, the Honorable Single Judge এটা included হয়েছে আমি right now 2070. My lord, I am handing over this state of Honorable Nirati Chatterjee, which the Honorable Single has relied upon, holding that only the ratio was that due to delay and that is not correct. That I will show.
Give them a copy.
Yes, I am certainly having. আমি স্যার আমি ওটা আমি আপনাকে দিয়েছি ঠিক আছে ওটা এটা 2017 দিয়ে দিয়েছি statement kindly come to this is fact remains that 401A was in here. So for this judgment is concerned. 401 was invoked, no award was passed. They have challenged, they have sought for the invocation of provisions in 2013 Act, but it was nullified.
But ratio in this matter can become straight away can become to
Page 27, the underlying portion.
yes. Malad, kindly come to Malad, page 26 I am stuck.
Yes.
Malad,
Yes.
page 26.
Yes.
If one looks carefully, one would notice that in the facts of the instant case, the land use requisition under allocation of the certain sir was handed over to the requiring body on 29/4/1970 for construction of water right, ex-Jamindari embankment, Tagira to Kuagra. Notification under section 41A of Act of 2, that is 1948 Act, was subsequently published in the Calcutta on 2nd July 1990. Although an amount of rupees 20 lakh 76 was sought for from the requiring body, executive immediate amount of, but the state authority simply failed to place the funds. Subsequently, after expiry of the 1948, 31st March 1997, it expired because it is a matter 31st March 1997, the act expired because it was a temporary act. Time to time, it has been extended. It was extended. But the state authority simply failed to place it. Subsequently, after expiry, the collector of Bardhan simply abdicated its statutory duty to issue under section 93B of the Act of 1800. This could be either due to sheer carelessness or negligence on the part of the collector of Bardhan. Undoubtedly, it is only due to the collector's failure to issue a notice under section 93B of the Act, land acquisition proceedings to lapse. Can you see? However, here they might mean. However, whether ipso facto such a lapse translates into claim for compensation under the provisions of Act 2013 can be answered simply by visiting section 24 of the Act of 2013. It will be noticed from a plain reading that the said section there is a phrase proceeding initiated under the Land Act 1894. In the facts and circumstances, it cannot be held by any stage of mention that proceedings were ever initiated under the said Act of 1894. As such, abdication of statutory duty on the part of the collector to issue notice under section 93B of the Act, either due to sheer carelessness or negligence on his part, cannot ipso facto translate into a claim for compensation under the Act of 2013. We do not know what prevented the repetition of then manner. Can you see? This is the latches and negligence, that part. So there are two issues. One is clear ratio was that if it is initiated other than Act 1, then the proceeding, you have to complete the proceeding under the Act 1 to pay compensation and legal. And you can benefit the section 18 of the Act because of section 114 of 2013 Act, section 6 of the Organization. But then manner, this I am not reading because
the learned single judge here held that
only
on the delay point it is distinguishable therefore, but the other part was not
touched.
Okay.
Now, my lord, I am placing another division bench judgment, although the ratio is there, but my lord, it is not to the extent that there was no such. That is, I think, after all, it is a division bench judgment. I appear. I pointed out, my lord, kindly, whatever submission I am making, my lord, kindly. How, my lord, that submission was not made. However, the ratio is there, my lord. I am placing, my lord, the another division bench judgment. It is a my lord, here, my lord, this is also a division bench judgment. My lord, kindly see. My lord, here the honorable single judge passed an order. That is the West Bengal Land Regulation. Here also, initially, by consent of the parties, appeal and connectors were together. Petitioner approached the learned single judge with the grievance, although their land was initially requisitioned, thereafter acquired under the Provisional Act 2 of West Bengal Land Regulation 95. No compensation has been received till then. According to them, possession of the land was taken over in the year 1982-83. The learned signature referred the revised report in the form of affidavit filed by the and noted that the compensation on 11 lakhs had been determined but not paid to the register. Learned signature directed the respondent to determine the market value of the right imposed in terms of the provisions of the right to fair compensation on 25. Being agreed, state this before us in this session. My lord, we have heard the learned counsel of the parties. The order of the learned signature cannot be sustained since the acquisition of the land in question was initiated under Act 2 of 19 but not under Act 1 of Land Acquisition Act 11. Since Section 24 and 26 cannot annual to the benefit of the writ petitioner, this means the writ petitioner will not be entitled to the benefit of determination of compensation in terms of the provision of 2013 Act. And the order of the honorable signature therefore is stated. However, the writ petitioner must receive compensation as determined by the such and such by
Act 1.
Act 1. Can you see any character shall provide such component in the award to pass as the envisaged in the 18th. So the ratio is, my lord, the same.
Same.
Now, my lord, I am handing over, though this is an auditor, but however I will show auditor is also a bandit discipline upon my lords. This is a coordinate case. This is my lord's chapter.
Supreme Court submitted is binding.
Yes, Supreme Court submitted is binding.
This is Supreme Court.
This is my lord's chapter. This is
No,
auditor.
High Court submitted is not binding.
Yes, my lord, but my lord,
Supreme Court submitted is binding.
I will show, my lord, that this is the presiding judge was my lord.
Then it is all the more not binding.
Yes, kindly consider. I will show that the Supreme Court judgment. Kindly see page 10, sir. But straight away, this is not related to that issuance of section 41 that in this proceeding it was issued under section 6 and section 4 and 6 of Act 1. There, my lord, I made a submission to that extent, even if the section 4.6 was initiated, if initiated, then it will be proceeded as per the latest Supreme Court judgment. I don't know that judgment. Also, my lord has got that you have to go through that proceedings, but only section 26 of 29 regarding compensation you have to make up. Even in that it doesn't lapse. Now, my lord, kindly see, my lord has paragraph 47. This is relevant. This is about my case. Well, however, I not, because I want to say whatever is there, I want to read out it. Paragraph 47. Thus, in a requisition scenario, under 1948 Act, requisition land based absolutely in the state government. Simultaneously, before that ballot, that 90 ballot has all deliberated. All has gone through the and quoted that 1990. Everything is ballot has noticed. Thus, in a requisition scenario, under the requisition land based absolutely in state government simultaneously with the publication of notice of acquisition in the official gazette under section 41A of 1948 by operation of subsection 2 of section 4 of the State Act. Even if subsequent timeline for passing the award absent and already vested land cannot be divested and reverted back to the original. In the present case, however, stage of section 9 notice was never reached. Acquisition proceeding was still born baby, being certified at the stage of declaration of section 6 system 1949. This is not an outer to show the acquisition proceeding proceeded any further after declaration of section 6. This is under area. That's why, however, that ratio is there. But I can take the advantage of that. And my lord, sorry.
Yes.
Sorry.
Yes.
Here, my lord, main issue was
In a
that,
different context.
main issue was that, because I made a submission, the humble submission before my lords, that even if a wrong order be passed by the PLR, that will be governed by the, my lord, the specified act, and the repetition is not maintainable. However, my lord, no, this is not that. My lord, I am not on that. But in that background, my lord has dealt with regarding that section. Once if it is this scenario, this can be done. But the facts are totally different. But however, the ratio is there. Now, my lord, I am placing the latest reportable judgment of the Supreme Court regarding binding precedent and obiter. My lord, though it is a settled principle of law, because my lord is always searching for that new judgment. Now, this is January 5th, 2026. My lord, I have this. But stated, my lord, this is, my lord, a fact, my lord, relates to the fact. So, for this case is concerned, my lord, that notification once issued and it was quashed regarding custom duty, whether you have power. Subsequent notification, whether that can be challenged further or not. That was a point it was discussed by the Honorable Appeals Court and came to a finding. Since original notification was quashed on the basis that the division bench clearly held that you have no right to impose tax. So the foundation of that, setting aside of that notification, earlier notification, if it remains intact, even if subsequent notification, even if we made, but foundation is the same. That's why there was no requirement to challenge that subsequent notification. That was the on the base. And my lord, the binding precedent, my lord, can be page 77, paragraph 77.
Yes.
My lord, guys, the discipline expected of coordinate benches does not permit such an approach, because in the original the division bench, now the another division bench has set aside that because yes, it is you have to challenge. So in that scenario, in that background, my lord, his judgment was pronounced. The discipline expected of coordinate benches does not permit such an approach. This court in state of Uttar Pradesh versus Ajay Kumar 2016-15 SCC has reiterated that once a coordinate bench of High Court has settled a question of law, a subsequent bench of equal strength is bound to follow that view when confronted with the same issue. If the latter bench believes that the earlier view is so manifestly erroneous and or incapable that it ought not to be followed, the latter bench must refer the matter to a larger bench for reconsideration. What it cannot do is to sidestep and whittle down the earlier pronouncement by confining it artificially. This is very important. Artificially or by treating it as a fact-specific indulgence. Absolutely clear. This point was not there in this judgment, but it is clear in this judgment. Even a fact, you cannot distinguish that facts are different and change them. That's why, that this is very important. By confining it to artificially, you cannot sidestep or whittle down. For down earlier, by confining it artificially or by treating it as a fact-specific indulgence. This is very important. Now, the discipline of precedent is not a matter of personal predilection. It is an institutional necessity. Stare beside this. At 8 non-quota mover, which means to stand by what is decided and not to disturb what is settled, is a working rule which secures the stability, predictability, and respect for judicial outcomes. The law cannot change with the change of the page. In the present case, I think, the present case decision means I will not. So, my lord, my
Yes.
So, my express submission would be to coordinate bench. Hey, and not that it is utterly illegal patent, there is a patent, there lies a patent illegality. Because on the basis of reading of section 20, and my lord, those that I because this is not the, because my lord has already gone through that Bangalore development of that if it is even that section 24 was interpreted, that if it is not initiated, no.
Why aren't you referring to Bangalore Development Authority now?
I am not referring, because even if Bangalore Development Authority in the judgment, my lord has passed another where it was specifically held by reading down or by not reading down, because by reading the extent of section by interpreting section 24 and held that once it was issued, the notification be issued under the, not under the Act 1, but under the different Act. Then 2039.
Bangalore Development is an authority for that.
Yes.
So why aren't you citing that? You are also taking the same point.
Yes.
That this was a notification issued under the 48.
Yes. But when a Bangalore Development Authority, why I am not citing? Because I have to be frank. I have to be
somewhat different there.
I have to be candid. Yes. Something, because there the doctrine of incorporation, doctrine of referendum was in, because it is not, because this law, the temporary law goes.
Oh, right. That was regarding the other 48.
This temporary act goes. So, that's why I am not citing.
Okay.
But the basic thing, the interpretation of section 24 is clear. So it cannot be the permitted to allow this whittle down.
Okay.
On the basis of some difference in the question of fact or something like that.
Then what act will apply? Your second question?
Obviously, because I am saying that obviously, they cannot
without compensation. Cannot be without compensation.
Yes. Well, this is absolutely, this is the basic foundation of the rule of law. Because I am extracting, or I am taking the land, I have to compensate. Now, my lord, sorry. Yes. Now, my lord, kindly come the larger judgment. Because I have to point out, because whatever is there, I have to, my lord, I have, it is, well, here, my lord, here I am pointing out, kindly consider one. This is the judgment was delivered on, my lord, that is sometimes decided 17 June 2011. At that point of time, 2013 Act has not come. And the interpretation of section 24 was not done. As in the
other,
that is the constitutional.
So
because even in constitutional bench judgment, my lord, yes, something is missing. But my lord, missing means, my lord, suppose, my lord, a hypothetical situation, my lord, can you consider? Section 410 was not involved. Only section 3, coalition was involved. In that section of government, then section 3 cannot be treated as an initiation of process, because it is not an acquisition, it is a requisition. So my lord can distinguish that in that event and pass an order, yes, it will be covered by
that would be much easier. Yes. No acquisition at all.
Yes, no acquisition. This is the distinction, my lord, regarding issuance of section 3.
In this case, what was it?
4190. And in every case that I have handed over the judgment, here also 418 was in.
No, please show us that ratio.
In the larger than judgment.
Yes.
Yes, larger than judgment, my lord, in a nutshell, my lord, I am making humble submission. Larger than judgment, my lord, though, my lord, I respect him, sir, Mr. Jordan Justice Bhattacharya. But my lord,
Till
It's
date.
intended for one of us.
Exactly.
This submission is intended for one of us. Without understanding the adverse consequence.
No, that was must have.
No, from the part of the bill.
Yes. Madam, only one thing, madam. I had a very respect to the Honorable Justice Mr. Bhattacharya. Madam, this is my personal feelings.
Come to the point.
Like to yes. Madam, no. I'm not.
Now the abuse begins.
Yes, yes. Madam, only one thing here. The discussion was made that two division bench judgment was there. One says 7A is not applicable. 7A of Act, that is 7A of Act 2, Joshua. Well, then, madam, ওই দেখুন এটা মোটা মধ্যে আছে ওটা থাকবে
ওখানে রাখারে চোখ
এটার মধ্যে থাকবে না মোটা মধ্যে আছে
ঠিক আছে
1948 Brand definition acquisition I think it is not there
এটা কি ধরাচ্ছ এটা অ্যাকুইজিশন এস্টেট অ্যাকুইজিশন Please continue with share.
Yes. Madam, here before reading the section 7A, because madam, here what has happened in this case, madam, regarding these.
Continue 7, yes.
Latter. Madam, there the facts on issue that two division bench held contrarily. One says 7A is not applicable. Another says that 7A is applicable. Vesting, if the vesting was not there within a statutory period, incorporated in 7, then vesting will go. In that scenario, even if 9(3)B would not be applicable, 9(3)A would be applicable. This is the sum and substance of the judgment of the Honorable Latter.
Give us half a minute to say.
It is there. Malada, it is written in the Latter bench judgment also, which is quoted. Everything.
Yes, God.
Yes, ma'am. Madam, kindly see, madam, after reading.
Oh, this is the unamended.
Sorry.
No, this is the official website.
Madam, kindly come to the judgment. Madam will find it. The judgment I have handed over. Okay. It is in the all sections are being incorporated. Well, let us come to the judgment, madam.
Yes.
Page 3 of 8. Madam, the
You have got that? Yes.
Yes, page 3 of 8. Paragraph 9.
Right.
Therefore, in all those matter questions that arise the determination as to if no award was passed under section 7A of the West Bengal Land Acquisition Act 1948 as amended by the West Bengal Land Act 96 within a period of 2 years from the date of commencement of the West Bengal Land Acquisition Act in 1994, whether by issuing a notice under section 9(3)B of section 9 of the Land Acquisition Act, the lapse notices issued earlier issued under section 418 of Act 2 of 1999 can be revived. This is the main issue. Whether vesting gone after introduction of 7A. Because there was a statutory period, here is clearly written 7A, if I not post the 7A, I think it is written. 7A is not being incorporated. However, under 7A says, my lord, these are amended provisions when that act was in subsistence, 1948 Act. My lord,
Yes.
there I join issue. The honorable division may held that if it is contrary to in some substance, if it is contrary to section 7A, then vesting on earlier issues noted that the vesting will not come, or vesting will not remain.
Yes.
7A kind of section 7A, it says that if the award is be not passed within such and such statute period, then vesting the section 41A will go. That means vesting will go.
Yes.
And 41A kind of 41A says once 41A has been invoked, that property or land or whatever is vested to the state become order. This is like 17.1 of Act 1. Now, kindly consider here the main issue whether the lapse notice. Suppose 2 years lapse before that, in the view when that amended act comes into force, incorporating the 7A. If the 2 years lapse, then vesting goes. Vesting will not be.
Special bench held that since the notice lapses, the vesting also goes.
Vesting.
But you say
Because
that
of section 7.
you say once vested cannot be divested.
Once vested, because why I am saying? Because first, even after that, first I will complete this thing. I will. Here, stated after discussing everything, kindly see the honorable larger bench held that even if 93B goes, you can issue 93A. Kindly see. Yes, can you see last 8 of 8 internal page. First minute I will complete this minute.
Yes.
We get the same pattern. With great respect to the said division bench, we are unable to accept the above interpretation of the amended Act 1996. Although the said Act was published in Calcutta 8 October 1996, the division bench totally overlooked the subsection 2 of section 1 of the very amending. It was specifically provided said amending Act should be deemed to have come into force on April 1, 1994. Moreover, after the provision to section 7A, the date 31st March 1994 was specifically mentioned after the word that Act was totally escaped the notice of the said division as would appear from the quotation of the said provision. Thus, there is no scope of interpreting the word that Act as the said act amended by ignoring the date of commencement of the West Bengal Land Acquisition Act 1994, specifically mentioned at the end of the provision. Where the intention of the legislature was clear, there is no scope of ignoring the specific language employed in the statute. Thus, by amending Act of 1996, the proceeding in respect of notices given prior to 31st March 1992 stood lapse. If the award was not published within 1 year from March 31, 1990, we thus find the learned referring division bench of this court rightly refused to follow the view taken in the case of State of West Bengal versus Somikhi. In view of the absent priority, we dismissed first 3 appeals by the state and affirmed the order passed by the learned single. So far as the fourth matter, W such and such State of West Bengal is concerned, we give an opportunity to find out the alleged notice under subsection 1 of section 184 of the Act. If it appears such notice was issued prior to March 31, 1990, the same should be treated we have left, and the state shall give and fresh notice under section 90 of that and will proceed that. So not that
acquisition proceedings to entire acquisition proceedings to lapse. Even the larger benefit. Now, my lord, I am pointing the infirmity. I should not say that. But how about, my lord, the infirmity? My lord, kindly see the honorable, the larger hail and rain. Where is that track? I just point. I just. May I kindly see, honorable judge, while going through the 7A. May I kindly see, judgment was delivered on 17 June 2011. 31st March 1997. There is no existence of the act.
So does this act, where does this judgment say, Mr. Sengupta, that by dint of 7A, the notice lapses and the vesting also goes?
Yes, yes. It is there. 7A. Yes, it is there. With the provision, can you see?
No, in this judgment, where has it been held? Provision says notice will lapse.
Notice under section 401A lapse, should lapse. That means 401A says that vesting will take place as soon as the notice is to be published. So in provision, there is a thing that if it is not award is it is not passed by benefit of amendment, then proceeding the initiation under section 401A will go. Then should lapse. That means vesting. In other words, vesting will go. That is
what we I mean, there is some doubt.
Yes, that's why. That's
because the vesting should also.
Yes.
Because the languages used in 412 and 7A are different.
Yes.
Whereas 412 says immediately with the notice, it will vest absolutely.
Absolutely.
Vest, if something vests absolutely, there is no question of going back.
And there is no such law.
No. But 7A does not say the vesting is vitiated or something like that.
No, there is no such clear.
Only the notice lapse.
Notice lapse. Yes. My lord is absolutely. I'm pointing out. I will point out
because we cannot go back in time and
Yes.
divest the vested property.
Yes.
But then the procedure would be a fresh notice has to be.
And remember, my lord, kindly see. My lord, kindly see with respect to the.
But if a fresh notice is used,
yes,
then
with
what would be the
respect to
alternative?
Yes.
What would be the alternative according
Yes.
to you?
Alternative.
We accept your submission prima facie.
Yes.
And yes, vesting is not taken away.
Yes. Now, my lord.
But then what happens?
And now,
if another notice is given under section 4, then there will be a second vesting.
That cannot be.
Then according to you, what should be the procedure?
My lord,
where should we start from?
Yes. Once
With the compensation.
Yes. Once vesting is done. My lord, first of all, my lord, so far this judgment is concerned.
Then for the purpose of compensation only, there will be a fresh proceeding.
1894, the compensation and whatever is there.
Where should this proceeding, this new proceeding start from?
From the date of my lord, the section.
Under which section?
Section 6(9), my lord, I will show that. I will show that first, my lord. I will
start afresh if the notice lapses, but it is already vested by the notice.
Vested on the
lapsing is something different from the notice being nullified.
Yes.
Lapses means there is a time in between.
Time in between.
The word lapse incorporates a time element.
Yes.
So after a time it has lapsed.
Yes.
But at the inception it was valid.
Valid.
If that be so, at the inception there was vesting.
Yes.
Vesting is complete.
Complete.
Then if it lapses subsequently, what will be the penalty?
That is the interest, the compensation under the Act 1.
From which section? From which section does it start?
Yes, 23, my lord, I will show that. I will show that. I will show that later on, my lord. But, my lord, so far this judgment is concerned, my lord, I am ready submitting on the twofold submission. First, my lord has already made an observation. I am not going to that. I am not repeating.
Yes.
Second, my lord, this is very judgment. My lord, kindly see the Land Acquisition Act. Now, first, my lord, Land Acquisition Act.
No, then should it start from section 5 of the 48 Act?
No, not that.
Notice to persons interested.
Well, 48 doesn't exist. There is no existence in the 1948 Act. Man, kindly consider. In the 1948 Act, there is a provision. There was a provision that regarding compensation and the award, it will be governed by the 1894 Act. That is the Act 1. Well, I will show that. Well, I will show that. Well, kindly consider one thing first, my lord. I am actually making a submission regarding this law laid down by the larger name. That is, first, my lord has made an observation. I am not on that. I am not repeating. Second, my lord, kindly consider first. There is no, at that point of time, there is no existence of the act. How? Well, suppose there is no act. Whether, unless in the act, that is the amended act, what is the function? That is to be vital. Otherwise, it will be redundant. Now, my kindly comes to 93 and 93B. First, my 93B kindly comes. Amended act. What? 98. 93, I am not on that. Also, Malad can read Malad, but Malad 93 is very important. Why I am saying vesting remains is a legislative intention. Kindly say, otherwise it will be redundant. Kindly, I am ready. 93, Malad, I am ready. Because section 4.1 was invoked here. Collectors shall also serve a notice to the same effect on all such persons known or believed to be interested in any land, or to be entitled to act for persons so interested. The position whereof has already been taken on requisition under section 3 of the said act. Fact. Admitted fact. Notice for acquisition of such land has to be published under section 1A of section 4. Admitted fact. And in every such case, provision of this is very important. Provision of section 4, section 5, section 5A, section 6, section 7, section 8, and section 16 of this act shall be deemed to have been complied. Here in the living provision. Why? Well, there is a two types of acquisition regarding for award, making an award. One under section 16, unless compensation be made and award be passed, there cannot be, you cannot take physical possession. And after taking physical possession, yes, acquisition. Unlike section 17, if it is invoked, section 17.1, then automatically land vested to the state. Even 11A is not applicable. That is the judgment of the constitutional. I am not on that, but is parameter to this. Because vesting, because the statute says, if the statute, I have not understood that the statute says in 93B, 7A provision, that vesting to lapse. Then, even in that case, I can argue it is not there. Only 4.1A that notice should lapse. But vesting is a thing that is accrued to the individual, maybe state or private party or something like that. If the accrual is being made in terms of law, then if any subsequent law, yes, it can invalidate. But there should be a specific provision annulling that vesting. On the contrary, my lord, the amended act says, I am ready. Because section 14 is not applicable. Section 16. Because position has already been taken. 4.1A. Now, my can see, this is very important. Provided that the date of publication of the notice of section 4.1A of the shall be the date of reference for the purpose of determining the value of such land under the act. Provided further, very important. Provided further, in every such case, collector shall make an award under section 11 in respect of such land. Because it is in the amended provisions, my lord is actually asking for that. Mr. Shenmukta, how can the prosecutor can be covered? It is there. To make an award under section 11 and in respect of such land, provided further in every such case, collector shall make an award under section 11 in respect of such only for the purpose of payment. Malad got it, Malad got the answer. The payment of due compensation to the person interested in such land has, Upon the collector taking possession, they were already vested absolutely the people of then, my lord. Then, if my lord, if the precedent says the vesting will go, this totally redundant, this will be totally redundant, this amended provision. Has, kindly see, has upon collector taking possession thereof, already taken possession. Already, kindly see, each word has to be given effect. Already vested absolutely the royalty from all. Then, my lord, in that, my lord, 9th CB, that the amended act, my lord, it has already, my lord, it was introduced in the after that is the expiry of the that is the Act 2, 1948, 31st March 1997. But my lord, before that the amended provisions which vesting, that legislative intention vesting will remain. Then, my lord, if something is, well, kindly consider, this amended notification was taken into consideration
But
by
the special bench judgment, does it say that the vesting also lapsed?
yes,
Fair.
yes.
Because here it is said that 9C,
No, yes, 19B, my lord, can see, I'm saying.
9CB was directed, 9A was directed.
It was the solvent head that vesting got. My lord,
Just that portion, yes.
my lord, the first point, my lord, kindly come back to my lord, again page 3 of page 8, the question. In all this matters, sir,
Yes.
in all those matters, that arises determination as to if no word was passed under section 7A of the West Bengal Land Division Act 1948 as amended by school circumstances within a period of 2 years before the commencement of the West Bengal Land Division Act 1954. Whether by issuing a notice under subsection 3B, because once 4 is 9C, section 9 of the Land Use 1997, lapse notices, lapse notices earlier issued under section 4A or Act 2 can be regarded. The Honorable Delachan said no. You can proceed with 9C. That means vesting.
But we don't have the luxury of distinguishing a special bench judgment. This is binding on us. It's
But
not a coordinate bench judgment that we can say different.
That's why I am first.
This is binding on the division.
Yes, at the first blast, my lord, kindly consider one. That what will happen? Which act is to be followed? Whether 2013 Act.
No, Act, that special bench also says the 1894 Act will force. 9.3A, vesting gone from 9.3A stage onwards.
Yes, 9.3A stage onwards. So, my lord, if vesting, my lord, what I am saying, that subject to my lord second kind of work.
But even if you differ from this, I mean, cannot differ from.
But my lord can because the larger. Yes, whether this my lord can say that because this, that's why I have placed that.
We are sitting in division bench.
But in the division bench to coordinate bench, even after this.
This is not a coordinate. That is what we are saying.
No, my lord.
We agree with the division bench judgments you have cited before.
Yes.
Those we are agreeing with. If we had a quarrel with those, then we would refer it to a larger bench. But this is a larger bench, and we are bound as a division bench.
Yes. But that's why in that scenario,
if your judgment is applied, this should violate the judicial decorum.
Judicial
You can just distinguish.
What
I am bound by this.
Yes, what I am.
Special bench.
Special bench didn't say because that was got at that point of time. Which act would go? Special bench says.
No, on
1894 Act.
Not on that question, but you are mixing up the questions, Mr. Shenmugh. Because that is a different question whether 2013 Act would follow. That was not decided. But it decide this judgment decides the question as to the question which has been framed. Vesting. So as per this judgment, vesting goes and you have to start from 9.3A, not 9.3B. How
9.3A, not 9.3B.
Not 9.3B, 9.3A. That is what you are saying. So if 9.3A, then vesting goes. Requisition stage, so after requisition. So then, Mr. Shenmugh, how can we differ from this special bench judgment? This is squarely binding on us.
We
may have a different interpretation. But even then, this is binding on us.
And may I put it in a different way? Subject matter standard. Well, I have made a full submission. One way I put is,
Even if we accept your submission, Mr. Sengupta, we have the luxury of deferring with a special bench. We don't find any law of precedent permitting us to do that. That will be absolute judicial anarchy. We may feel otherwise. We may differ from this logically, but we don't have the luxury of referring a special bench judgment by differing from it.
well,
Finding.
if I correctly understand my lord's observation, well, kindly consider one thing. That's why I have made, on the first blush, I have made two scores of submissions. Because
This is not an adjudication on 2013 Act applicability.
yes. So if my lord
That that is a different point altogether.
altogether different, but my lord there the
But if we are bound by this judgment, then we have to start afresh from 9(3)(a).
yes.
We have to hold that. And we are bound by this special bench judgment. We have no other option but told him to start again from 9(3).
Well, may I make one indulgence? Kindly put on next Thursday, my lord. Next Thursday, so that my lord, I can find out whether
Every time we ask a question, and
no, whether I will find out and on this research that whether the honorable division,
two judgments can differ from a three judgment.
no, what I am, because in some cases, I will look up or I will go through that judgment where it has been held that constitutionally, even large bench strength is not enough. That proposition of law is there.
Same High Court,
But that's why I will find out.
same family.
But I will find out. I will find out, my lord.
No, but this judgment, you are right. You have a point. Subject to hearing your other side, we are prima facie impressed by your argument that this is not the correct proposition. But then we are bound by the special bench judgment.
Well, that's why, my lord, can you fix it? Please call Thursday, because my lord is taking up that matter on Thursday.
Whatever it is. Any other point, Mr. Sengupta, you can conclude your other points. And
Yes, virtually completed.
no, the virtual, remove the virtuality. You complete your arguments only on this point. On this, we'll
Yes,
then
on this. Well, then, yes.
the other portions. Heard learned senior government advocate appearing for the state. Question: although the arguments of the state are virtually concluded, comma. Learned senior government advocate seeks an adjournment to cite judgments, comma, if any, comma, on the question as to whether a division bench can distinguish or differ from a judgment rendered by a special bench of the same court comprised of three judges. Which of the next para, accordingly, let the matter stand adjourned for further hearing till January 15, 2026.
Yes, obvious. Pattern, make it pattern, because already my lord had it.
After saying so much, it
Yes.
was testing. আচ্ছা তাহলে একটা ইয়ে প্রথমে করে দাও হার্ড ইন পাঞ্চ yes, otherwise you will waste you have wasted time, they have wasted time, your own time, not our time. Oh, আরেকটা লাইন অ্যাড করে দিতে হবে, the rejoinder to reaffirmation of the report, comma, filed in court today by the land user, because you are appellant in the one. No, you're the by the land users, be kept on it.
But BSNL has given some instruction, but on the late statement, land has already been acquired, possession handover, and we have repeated the.
Yes, we'll hear you and record your submission.
Yes,
Honest.
to the photograph that it has been done.
No, if we set aside the entire thing, no, if the entire thing goes, then the whatever you have
As the instruction of the land acquisition officer, we have paid the entire amount, check, photocopy of the check with me.
everything can be reversed if the entire proceeding is set aside. If the vesting goes, then you don't acquire a right.
acquisition on the part of the state, my lord, where the
That's what we are saying.
My-
If they don't acquire, the state doesn't acquire the right, you don't acquire it.
Yes.
Person does not having title cannot grant title. That is the crucial aspect of the matter. এটা আছে হ্যাঁ এটা critical করে রেখে দিতে হবে। এটা একদম file এ।
Item number 10 with 11.
10 and 11 as will appear for the corresponding petition. Therefore, my learned friends start by speaking a small liberty from your object that have been led by the most Dr. If my learned friend concludes his argument today, can you give us another day to give a conclusive reply to this?
Then Mr. Gupta, should we start today? Piecemeal hearing, maybe it will be concluded within one day. If we start today and again keep it parted,
We have no difficulty.
you understand?
Then any day, my lord, can you
At least it might be convenient.
Yes. It's always going because we may
So far as understanding of
will again forget and will again remind us and all this.
That's why I mentioned it.
You are also appearing.
And I kind of kindly fix up a date, man, because the difficulty is that urgency is on our part.
No fixing up.
Well, next month, 15th or
You understand the importance of Mr. Chakraborty. But we cannot fix a date for him. Whatever applies to him applies to all the other councils. No, none of the council in this court know when their matter will be taken up. But they are present before us. Every time your learned friend is present, as they are all. You are also present.
I know, my lord.
So for Mr. Chakraborty, we cannot fix a particular time. For any council, not for,
Definitely not.
we are not distinguishing against Mr. Chakraborty.
Definitely not.
An adjournment is sought on behalf of the respondent. Full stop, next para. Accordingly, let the matter stand adjourned till January 15, 2026, with the expectation that the respondent shall come prepared on the next day when the matter is called on. If he does not argue, you will have.
I will.
That's why I put in the last slide.
I will, my lord. And it's always an honor for me to get an opportunity, my
It's a
lord.
pleasure to hear all of you, but you have to give us the pleasure.
My lord.
Yes.
Grateful, lord.
Thank you.
Item number 12.
Yes. There was a direction by the coordinate bench, my lord, to prepare the paper books, my lord. And
Yep.
write the paper
Yes.
books. Copies have already been served upon the respondents, my lord, the appearing respondents.
Have you got the receipt of that?
And there was also a direction by the coordinate bench, my lord, to comply with the deposit of cost which was imposed by the single judge, my lord. That cost has already been imposed. My lord, this is the suitable imposition of cost and the photocopy notices of mention as well as the service of the paper books of the respondents.
You are filing the paper books today in court.
Yes, sir. But it has already been served on the respondents.
Sure.
The direction also to comply with the order of the learned single judgment to deposit the 1 lakh cost which was imposed by dismissing the petition.
So what about the service of the paper books? That
Yes, but the paper books have also been served. The notices are there, the mentioning notice as well as the service. May I start, my lord?
yes, we'll just record this. Learned counsel for the appellants files the receipts in respect of service of copies of the informal paper books on the learned advocate for the respondents, as well as receipt in respect of payment of the costs as per previous direction of court. Full stop, next para. Such receipts are kept on record. Full stop, the paper books filed in court today also be kept on record. Full stop. The matter is taken up now in view of the absence of the respondents, comma, despite the matter appearing in the list, comma, the matter is taken up for hearing expertly against the respondents. Yes.
Yes, madam. The subject matter of challenge to the matter is the judgment dated 20th of February 2025, whereby the honorable single judge had dismissed my writ application, my lord, where I had challenged the land acquisition proceedings in respect of my land, my lord, holding that the writ petition was not maintainable, as well as imposed a cost of rupees 1 lakh. Now, my lord, before placing the grounds of challenge, my lord, I'll just place the appellant number 1, my lord, is a
private limited company, my lord, represented by the applicant number 2, who is its managing director. Now, my lord, the applicant number 1 company had purchased certain plots of land by the sale deed in the year 1995. The plots of land in question, my lord, which are the subject matter of challenge, my lord, plot number 86 and plot number 86 by 332. The sale deed that is annexed as that is there at, my lord, volume 2 of the.
We'll look at the sale deed first. Just make your submissions on the please.
So, my lord, on these plots of land, they were purchased by the applicant company in the year 1995. Subsequently, my lord, in the year 2006, a notification of the Section 4 of the Land Acquisition Act 1894 was published, whereby, my lord, the lands were sought to be acquired for a public purpose. If my lord sees page 43 of the paper book, volume 1 of the paper book, my lord, that is the Section 4 notification. My lordship will find that the purpose for which the lands are acquired, my lord, may I just place the paragraph, my lord, page 43, volume 1 of the paper.
Will you just tell us the facts? Because the purpose was public purpose.
Public purpose.
They did not
With
use.
my contention, my lord, at that point of time, we were not aware of the land acquisition proceedings, my lord. Subsequently, a declaration under Section 6 of the Land Acquisition.
You had purchased a clear. It was a purchase, private purchase from someone.
It was a private purchase from someone.
In the year
1995.
1990. Acquisition, they say, was before that.
No, the acquisition took place in the year 2006. The Section 4 of the section.
You were already the owner there.
I was already.
For notice was much after that.
Much after that.
Yeah.
The year 2006.
So then,
subsequently, my lord, in the year 2007, there was a declaration under Section 6. It is our contention, my lord, at that time we were not aware of the land acquisition proceedings. But the first time, my lord, in the year 2012, we came to know that the West Bengal Industrial Development Corporation, supposedly the requiring body, had executed a lease deed dated 11th of September 2012, whereby they had granted a lease for a period of 99 years in favor of one Ganpati Flour and Foods Private Limited, who is the private respondent number 8. Now, my lord, the lease deed is also there, and subsequently, my lord, the purpose mentioned in the lease deed in clause 6.3, it states that it is being acquired for Calcutta industrial park, and the purpose which is mentioned, that is where, my lord, at page 69.
no, why did the Lord single judge hold that it is not maintainable?
Yes, my lord, I'm coming to that. On one hand, my lord, the learned judge held that my writ petition was not maintainable and imposed costs of.
Why not maintainable?
I'm coming to that, my lord. Because the prayer in the writ petition, my lord, it was perhaps not so happily worded. It was the prayer in the writ petition was not to give any effect to the lease. But in my pleadings, my lord, I clearly challenged the land acquisition proceedings. And on one hand, my lord, the learned single judge held that the writ petition is not maintainable. And in the same judgment, there's also another finding by the learned single
On
judge
merits.
that even on argument's sake, if the writ petition is held to be maintainable, and at the time of admission of my writ application, my lord, there was an order of injunction which was granted in my favor, my lord, and the point of maintainability, my lord, it was neither kept open, neither was it even raised by the respondents at the time of the hearing. Affidavits
But
were.
you have to satisfy this code twofold. One is that it is maintainable. One.
Yes.
And even if it is maintainable, otherwise the findings, adverse findings against you, if maintainable, then the rest of the findings, that also you have to overcome.
Yes, ma'am. My lord,
So what was the observation of the learned trial judge on merit?
yes, I'm coming to that. That starts from page.
He said it is a valid acquisition.
Yes, he held that the acquisition is valid. My lord, kindly.
So what is your ground for challenging the acquisition?
My lord, the ground for challenge, my lord, even though it was sought to be, there are three grounds for challenge. Even though it was sought to be acquired for a public purpose, my lord, which is mentioned in the section 4 and the section 6 declaration notification, it was handed over to a private entity, which is Ganpati Food and Power, which is private limited. Second ground of challenge, my lord, is that no compensation was awarded in my favor. It was because the plots of land, they belong to the company. A company is an artificial legal person, my lord. It is not the same as its director.
Who was it given to?
It was given to one Vivek Bajoria, who was previously the managing director and who had resigned from the directorship in the year 2003.
Before getting the compensation.
Yes, before the land acquisition proceedings, the award has been granted in favor of one Vivek Bajoria, who was previously the managing director of the company, but he had resigned in the year 2003. There was no award which was issued in the name of the company. And the third ground of challenge, my lord, is that these plots of land, they come within the jurisdiction of the Pitapur Kharagpur Development Authority, my lord. And as per the West Bengal Town, Country Planning and Development Act, my lord, prior permission is needed before, my lord, conducting any activity or change of use or nature or character of the land in question, as per the statute. These are the three grounds of challenge. Firstly, my lord, that though it's sought to be acquired for public purpose, it is being given to a private entity. Secondly, my lord, there is no award issued in favor of the company, my lord. It is issued in favor of the person who had resigned from the directorship. And third, my lord, the lands, they come within the jurisdiction of the Pitapur Kharagpur Development Authority and no prior permission was taken prior to acquiring. These are the three grounds.
The permission is required to change the nature and character.
Yes, yes, ma'am.
So we'll look into the provisions later. These are the broad grounds.
These are the three grounds, primary grounds of challenge.
Very good. Now we can proceed in.
Hello, first ground of challenge is the writ petition was dismissed, my lord, holding that it's not maintained. Because, my lord, kindly comes to page 266, the impugned judgment. From paragraph 14, may I place the judgment?
Paragraph 14, yes.
May I place
On perusal, yes.
on perusal of the prayer portion of the writ petition, as has been discussed herein above, also it appears to this court that the writ petitioner has prayed for an appropriate writ against the respondent authorities for not giving effect to the deed of lease dated 6th of September 2012, as has been executed by and between the respondent number 7 corporation and the private respondent number 8. In considered view of this court, that the relief as claimed in the writ petition does not come under the purview of the writ court, since it is a settled law that in the event the party intends to avoid a registered deed of lease, which according to him is going to affect his right, title, interest, his remedy lies at the common law forum, since the civil court has machinery and power to determine a person's right, title, interest over property by recording of evidence and by exhibiting documents. Though the respondent number 8 is not represented, this court has occasion to go on through the affidavit in operation as filed by the respondent number 8, wherefrom it appears that the present writ petitioner filed title suit number 16 of 2023 against the private respondent number 8 in the court of Civil Judge Junior Division, Second Court Vehicles, with a prayer for declaration and other ancillary reliefs in respect of plot number 86 and Bata plot number 86 by 332. This court thus considers that since the writ petitioner has approached the civil court by availing alternative remedy, that is by filing of title suit number 16 of 2013, this court must refrain itself from holding any order of restraint over the self-same lease deed in respect of the self-same plots of land, since the same may have an adverse effect over the judgment which is proposed to be passed in the said title suit. This court thus holds that on this court the instant writ petition is not maintained. And look, I will concede that the prayer was perhaps not so happily worded, my lord, but if my lordship sees the pleadings in the writ petition, my lord, I have clearly prayed for the land acquisition proceedings to be quashed. May I just place the relevant parts?
Yes, let us finish this point first, then we'll go on to the next.
Yes, sir. May I just place the
Relevant parts of the writ petition.
of the writ petition
Yes.
that have challenged the land
You
acquisition?
precisely wanting.
My lord, kindly comes to volume 1, page 25, which is my writ petition. Kindly is, these are the grounds. Sorry, madam, page 27. Ground 8. For that, the right to hold property is to be protected under Article 300A of the Constitution of India, and as such, the said right cannot be taken away except due process of law. Due process of law means to acquire the land for public purpose, as envisages in the Land Acquisition Act of 1894, and without complying with said provision of law, the land in question should not be acquired as has been done in the case, and as such, the acquisition proceeding is bad in law and I will be second. And my lord, there are several pleadings where I have prayed for the land acquisition proceedings to be quashed. I will concede, my lord, that my prayer was perhaps not so happily worded, but in the form of my pleadings, my lord, it would be evident that I have challenged the land acquisition proceedings. The subject matter of the title suit, my lord, that was different. The subject matter of the title suit is for declaration as and permanent injunction. And over here, my lord, I challenge the land acquisition proceedings.
Prayer is very unhappily couched.
Yes, my lord, I will concede to that. But my pleadings, my lord, I have clearly challenged the land acquisition proceedings, my lord.
And you also asked for and commanding the respondents not to acquire the land.
And land in question.
Anyway, yes, very good.
So, my lord, that is the first ground on which the judge held that the rate petition was not maintainable. My lord, on the second aspect, the land, my lord, is being sought to be acquired for the public purpose as per the notification. I just place the notification number. Kindly see page 43, volume 1 of the paper book, which is the section 4 notification. May I just place it, my lord?
One second. Yes.
Page 40, volume 1 of the paper book.
Yes.
Whereas it appears to the governor that land as mentioned in the schedule below is likely to be needed to be taken by the government undertaking development authorities at the public expense for a public purpose, these employment generation and socio-economic development of the said
You are
area.
Mr. Dotto.
Yes,
You are arguing very well. What is the ground of challenge to this? Instead of reading the entire thing, first say that, then it will be easier for us to.
mention that it's being acquired for a public purpose. Subsequently, my lord, kindly comes to the lease deed which was executed in the year 2012.
So let us see the portion where the public purpose is mentioned. Let us come there.
Yes, my lord. Over here it's mentioned, my lord. Public
The first part.
for a public purpose. For setting up telephone and allied industrial units.
Very good.
That is the purpose which is mentioned. Now, my lord, kindly see the lease deed which was executed in 2012. That is at
Yes.
pages. It starts from page 63 of the volume 1 of the paper book. Executed between the West Bengal Industrial Development Corporation and Ganpati Flower Mill, my lord.
Yes.
This was the private respondent number 8. Kindly see, my lord.
So this is the requiring body is giving it to a third party.
Is giving it to a third party. And my lord, in the section 4 as well as the section 6 declaration, my lord, there was no mention of the West Bengal Industrial Development Corporation as the requiring body. There's no mention. Subsequently, we come to know in the year 2012 that the purported requiring body is the West Bengal Industrial Development Corporation, and they have handed it over to the private respondent number 8. My lord, kindly sees page 69, clause 6.3 of the lease statement. This is very relevant.
Yes.
May I read, my lord?
Yes.
Establishing of Vidyasagar Industrial Park. The lesser obtained freehold title, right, and interest of the project from the government of West Bengal by a deed of lease dated such and such, with the object of developing the land for use for setting up Vidyasagar Industrial Park, and it has been enjoined upon the lesser not to allow the said project land and or any building or structure constructed thereon to be used for any purpose other than any activity relating to setting up of engineering and manufacturing activity directly associated with it.
Why do you say this is not a public purpose? Industrial park will give a fillip to the economy of the state.
My lord, kindly but seize the work. I'm coming to that, my lord. And this is setting up of engineering and manufacturing activity directly related to it, my lord. Now, the private respondent number 8, my lord, that is one Ganpati Food and Flower Private Limited. What connection, my lord, they may have with engineering and manufacturing?
That also we were also wondering that.
Yes. And my lord, also, when a land is being, there's a judgment. Might be the industrial byproducts are used in the flour. I am not aware, my lord, but that can be the only ratio. Also, my lord, there's another point which I have, my lord. When it is being acquired by a company, the state may acquire a land for a company,
Yes,
but in that case, the deposit of money, my lord, that needs to be paid by the company itself with the judgment of the Honorable Supreme Court, which I will cite later. I have a copy of that judgment. If come to that later, 1.5. Yes. So this is the second ground, that those things ought to be acquired for a public purpose. It's subsequently being handed over to a private entity. And the third ground, my lord, is that there's no award which has been granted in my favor, my lord, because the owner of the plots of land is the company. A company, my lord, it's a settled law that it's an artificial legal person, my lord. It's different from its director. Kindly sees, my lord, the affidavit in opposition, which I have annexed in the paper book, where the name of the awardees is mentioned. Kindly sees page. Let us finish this point first. Yes. Now, page 69, we are at page 69. Yes. Let us go one by one. Yes. So, public purpose. Yes. But even then, if it's a food products or not, industrial park is being set up. Yes. And for that, it has been enjoined upon lesson not to allow the said project be used for any purpose other than any activity related to the setting up of engineering and manufacturing activity. Why is it not also related to public purpose? Because we are saying this in the context of loosely we are drawing an analogy from the new section 20 capital A of the Specific Relief Act and the schedule. The infrastructure projects also include, and the Specific Relief Act section 28 debars injunction from being granted in respect of not only infrastructure projects, but section 41 is also there, HA, which says that no services and facilities relating to this infrastructure projects, that is also covered. So generally speaking, we understand the services and facilities for an infrastructure project or a public purpose to be associated with that public purpose. So this is one of the components, this engineering and manufacturing activity for industrial park. I mean, why not? That is also handed over to one consultant power and food private limited, and but the purpose is public. Ganpati, whether it can do or not, that's public, my lord. But even then, my lord, the compensation that has to be paid by the company which it is being acquired for, my lord. There are judgments which are placed reliance on. It can be, my lord. I am not disputing that it can be acquired for a private company, but then also that's a different point. Your first point was not being sought to be used for public purpose. Yes. But how do you substantiate that point? Because it's industrial park and engineering and manufacturing activity for such park. Then in the my submission is, my lord, then in the notice, in the section 4 and the section 6 notice, it must have been mentioned that it is being acquired for that particular company, my lord, because the judgment. No, that's the second point. Yes. That's the second point. That is industrial park, public purpose is subserve. Oh, it was stated specifically by setting up telecom and allied industrial units, my lord. Thereafter, my lord, it changed to Vidyasagar Industrial Park. And thereafter, my lord, it's being handed over to the private respondent number 8, Ganpati Food and Power Private Limited. All right. Yeah. So that is the second point which I have, my lord. And the third point, my lord, is that there's no award which was granted in my favor, my lord. It was granted in the list of awardees. There's the name of one big Bajoria. Kindly sees the affidavit in opposition which was used by the state, my lord. It starts from page 107 of the paper book. The list of awardees, their names are mentioned at paragraph Page 111, paragraph 4G. And this is Vivek Bajori. Page 111, Vivek Bajori. This is in respect of the awardee plot number 86. And kindly sees, my lord, there are two plots, 86 and 86 by 332. In paragraph 4K, again at my lord 63 Vivek Bajoria.
Yes.
So there's no award as of date.
What the others?
The others, my lord, they are
Co-owners of that plot.
co-owners of that property. And my lord, kindly sees Vivek Bajoria, he had already resigned from the directorship in 2003. I had filed the supplementary affidavit, that is at volume 2 of the paper book, page 247. Page 247. This is the resignation resolution of Vivek Bajoria. And also the record of rights, my lord, kindly sees page 252. And this is page 252. This is a reply received by the DLRO to my RTI application. Kindly sees page 252, the third paragraph. May I place it, my lord? Shree Garden Resorts Private Limited for Director Shri Mahesh Agarwal is a recorded owner of plot number 86 by 332 and LR plot number 86. So the recorded owner is the company. The land acquisition proceedings were initiated in the year 2006, and prior to that, Vivek Bajoria, who has been shown as an awardee, had already resigned.
What was the notice date? We did not notice. Notification date?
Notification date, my lord, the section 4 notification that was published on 27 November 2006. So this is, my lord, the fourth round of challenge, my lord, that as on date there is no award standing in the name of the company, it is in the name of Vivek Bajoria. And my lord, the last and final ground is that
there is an award.
There is an award, but not in the name of the person who's land, not in the name of the company.
Mr. Datta, shouldn't you have gone under section 18 of the Land Acquisition Act? There was all sorts of challenges to even regarding the person to whom compensation is awarded.
No, our contention is you are aware of the proceedings at that point of time.
So yes, you are challenging the acquisition proceeding itself.
And apart from this, no,
but there was a valid section 4 notice.
Yes, there was a valid section.
Which you have relied on.
Yes, which I have relied on.
So under which provision of Land Acquisition Act, if it is not used for public purpose, it will revert back to the landowner. Shows that.
Yes. Now, may I just place one judgment on the
yes,
Supreme Court?
whichever way you proceed.
May I read it, madam? Where in a land acquisition proceeding, the entire compensation to the landowner is to be paid by the company. It starts from, my lord. Yes, page 429, paragraph 3. May I read, my lord?
Yes.
The only question that has been urged before us on behalf of the applicants, the High Court was in error in reading the two notifications as in substance amounting to a declaration that the land was required for a company. Section 6(1) of the Act requires that whenever any land is needed for a public purpose or for a company, a declaration shall be made to that effect. Further, the provision of Section 1 provides that no such declaration shall be made unless the compensation to be awarded for such properties to be paid by a company or wholly or partly out of public revenues or some fund controlled or managed by the local authority. This clearly contemplates two kinds of declarations. In the first place, a declaration may be made that land is required for a public purpose, in which case in which case, in view of the proviso, the compensation to be awarded for the property to be acquired must wholly or partly come out of public revenue or some fund controlled or managed by the local authority. Note, declaration under section 6 for acquisition of land for a public purpose can be made unless either the whole or part of the compensation for the property to be acquired is to come out of public revenues or some fund controlled or managed by the local authority. In the second place, the declaration under section 6 may be made that the land is needed for a company, in which case the entire compensation has to be paid by the company. It is clear, therefore, that where the entire compensation is to be paid by the company, the notification under section 6 must contain a declaration that the land is needed for a company. No notification under section 6 can be made where the entire compensation is to be paid by a company declaring that the acquisition is for public purpose. For such a declaration requires that either out of public revenues or some public or some a fund controlled or managed by a local authority. In the present case, it is not in dispute that no part of the compensation, and also this is the part of the judgment which I rely upon, that it can be acquired for a company, but in that case, my lord, the declaration under section 6 must specify that it is being acquired for the company.
So there is something to be considered here. It's there are two different kinds of declaration. There may be an acquisition for a particular company. Then whatever you say, the first scenario applies. But then here in this your particular case, it has been sought to be utilized for creating an industrial estate, right? So it's not exactly for this Ganesh food or whatever this company. It's not for the exclusive use of the company for its business. They are being given the charge of building up a particular portion of an industrial park. But for even for a public project, whatever may be the public project, certain companies may be interested with the job of doing that. So at the end of the day, the acquisition, the state may argue, is for a public purpose, which is building an infrastructure project or an industrial park. For that purpose, certain company has been interested to do a part of the job. So therefore, it is not an acquisition for this Ganesh food. It's not being given to them. If it was given to this particular company for their own business, running their own business, that will be what you are saying. But here it's acquired for a public purpose. You sought to be utilized for a public purpose, which is building up an industrial estate. For which purpose a component of that is being entrusted to this company. So therefore, isn't your argument defeated on that count? We accept this judgment. There is no quarrel with this proposition. But here it's taken for a public purpose and not for the use of a particular. Some company has to be interested. We are sufficiently prejudiced by the flower and food portion, but even apart from that, they may diversify. We don't know. I mean, they may diversify. So whatever, I mean, the purpose remains an industrial park, not Ganesh foods manufacturing business or something, or their sale of their products.
But my submission is that in the section 4 and the section 6 notification,
Public purpose.
telecom and allied industry.
A telecom is a different entity.
And allied industry. And subsequently, my lord, the name of the Vidyasagar Industrial Park that comes up for the first time in the list. The purpose is being changed, my lord, and ultimately it is being handed over to an entity which perhaps has no connection to any engineering or manufacturing activity.
But here, employment generation, the purpose was employment generation and socio-economic development of the area by setting up telecom and allied industrial units. Whatever this means, this does not refer apparently to a particular company. Telecommunication, you can understand. Telecom, I don't understand personally. I can speak for myself. And allied, maybe telecommunication or something like that, and allied industrial units. So here an industrial unit is being sought to be made. So where is the deviation from this?
But subsequently it's mentioned Vidyasagar Industrial Park.
Name of the park, the telecom and allied industrial unit may be named whatever. You are lucky that Vidyasagar is mentioned. Could be someone more recent. So just taken for telecom and allied industrial units, it's an industrial unit is being built there. Whatever may be the name of the industrial unit is something else.
May just please students or another, my satisfaction from this point
No,
of topic.
we are putting the question so that you can answer. I mean, yes, very good. What is the other judgment?
Hello, the other judgment. This is in Royal Orchid Hotels Limited and another versus J. Jairam Reddy and others. The relevant paragraph number starts from
Yes.
the relevant paragraph starts from
This photocopy was taken out for the purpose of the writ petition. At that point of time,
yes, perhaps.
appears to be. From the age of the paper.
Origin mathematics.
Yes.
Yes, and the relevant paragraph it's page 631, paragraph 37. May I read my note?
Because Mr. Dattu, we have recorded that the state is not appearing.
Yes.
So therefore we are proceeding exploring no difficulty on that.
Seven is appearing. Not responding number 7.
You are not there when you started. You have recorded that it's been there.
Therefore, the West Bengal Industrial Development Corporation, which is
Responding number 7.
requiring
Yes.
page 631, paragraph 37, may I just place these. The pleadings and documents filed by the parties in these cases clearly show that the corporation had made a false projection to the state government that the land was needed for execution of tourism related projects. In a meeting of officers held on such and such date after almost 4 years of the issue of declaration under section 6, the managing director of the corporation candidly admitted that the corporation did not have the requisite finances to pay for the acquisition of land, and the Dan and Pai, who had already entered into agreements with some of the landowners to purchase of the land, was prepared to provide funds subject to certain conditions, including transfer of 12 acres, 34 guntas land to him for house building project. After 8 months, the corporation passed a resolution for transfer of over 12 acres of land to Danan Pai. The corporation also transferred 2 other parcels of land in favor of Bangalore International Center and MS Universal Resorts Limited. These transactions reveal the true design of the officers of the corporation who first succeeded in persuading the state government to acquire a huge chunk of land for a public purpose and then transfer a major portion of the acquired land to private individual and corporate entities by citing poor financial health of the corporation as the cause for doing so. The courts have repeatedly held that in exercise of its power of eminent domain, the state can compulsorily acquire land of the private persons, but this proposition cannot be overstretched to legitimize a patently illegal and fraudulent exercise undertaken for depriving the landowners of their constitutional right to property with a view to favor private persons. It needs no emphasis that if land is to be acquired for a company, the state government and the company is bound to comply with the mandate of the provisions contained in Part 7 of the Act. Therefore, the corporation did not have the jurisdiction to transfer the land acquired for a public purpose to the companies and thereby allow them to bypass the provisions of Part 7. The diversification of the purpose for which the land was acquired under Section 4.1 read with Section 6 clearly amounted to a fraud on the power of eminent domain. My lord, coming to my last ground of challenge, my lord, that these lands they come within the jurisdiction of the Midnapur Kharagpur Development Authority, my lord. Kindly see the notification, my lord, at page 95 of volume 1 of my paper book. The type copy is also there, my lord. Page 95A. From the 6th paragraph, page 95A.
You can follow the main. Either of the two. You can read from anywhere.
From sixth paragraph, my lord, this notification
Yes.
dated 15th of July 2015. Now, therefore, in exercise of the power conferred upon the undersigned under section 45, read with section 56 of the said act, this public notice is hereby issued and published proclaiming that after coming into force of this act into the aforesaid planning area and subject to the provision relating to the development charge and other provisions of the act, no development, institution, or change of use of any land shall be undertaken or carried out in the aforesaid planning area as stated in the schedule annexed herewith without obtaining a certificate from the Midnapur Forestry Development Authority certifying that development charge as leviable under this act has been paid or that no development charge is leviable. And my lord, the schedule is there at page 97, the jurisdiction of the authority, my lord. My lands come within this jurisdiction.
The underlined one.
Page 97.
Page, the 1 to 6.
Yes.
Yes. No, this is a copy from. Yes. Very good.
These are my grounds of challenge. And these, my lord, the petition, my lord, could not have been. I did not suppress anything, my lord. I came to the court with clean hands, my lord, holding that it's not maintainable and then dismissing it with 1 lakh cost, my lord.
1 lakh cost was given.
1 lakh cost was given. And on the other hand, my lord, it's dismissed on the ground of maintainability and then it's in the judgment, my lord, there's also another finding.
What did you do to irritate the learned judge? You must have done something.
But I was not the arguing counsel at that point.
Very. And moreover, you may have a point that regarding maintainability also civil suit was said to be the remedy.
Yes.
If it's a simply the challenge on some other ground, I mean, title did not pass or the did your premise of challenge you were saying to the lease deed is that the acquisition was bad.
Acquisition was bad. And my pleadings I have also stated that in my writ application.
So therefore, you seek the remedy culmination of your relief is this lease deed should go.
Yes.
But that is on the ground that the acquisition is bad.
Acquisition.
That is what you are saying. And also, not only even if the acquisition was correct at the inception, it was taken for public purpose but given to a private party. So on that ground also, even if you did not challenge the acquisition per se, the acquisition remains. But even then, subsequently, it was given to a private party that would vitiate the conformance to the private party as well as the land acquisition.
Yes.
Very good.
These are my grounds of challenge, and I've relied upon those judgments.
Yes, thank you. Yes. Please answer.
My concern is, I am the respondent number 7 because
You are the requiring body. Why are you giving to a flower and food company?
I have stated I have filed actively in operation page number 174 of this volume number 2, 173. I
173 is there?
Malad,
Yes. Yes, here.
not really page number 175. This is my 175 page number 7 and Malad A.
You are respondent number 7 here also.
No, paragraph 7, Malad.
Here you are respondent number 7 also in the appeal.
Yes.
This is the writ petition. In the appeal also you are respondent number 7. That is what. Mr. Doctor, please clarify.
Yes, in the appeal, my lord, they are the respondent number.
Yes, ma'am.
Yes, respondent number 7.
Please continue. Yes. Mr. Doctor, take your seat. Yes, Mr. Adok, please.
Paragraph number 7.
Yes.
Paragraph number 7, WBIDC, West Bengal
Right.
Industrial Development Corporation, who are you, being an agency of government of West Bengal, takes part in the development of diverse state projects for furtherance or economics and as such takes part of the development of industrial park in various allocated areas by this government of West Bengal.
So you are acting as an agent of the government. It's not that it has been given to you, but through you, the government is undertaking this project. Now, can you explain what was the purpose? What is this telecom and allied? What do you mean by telecom?
Paragraph number B. Considering the
on page number 4,
Yes.
176. Considering the proposed project and requisition of this West Bengal Industrial Development Corporation, the government of West Bengal find a proper initiative and acquisition proceedings, and after completion of the same, handed over such land to WBIDC for development such economic zone according with law. But what has happened, my lord? Next, my lord. My lord. Paragraph D, my lord, page number 4, my lord, Roman 1. Taking purview of the lead industrial activities, the district Paschim Midnapur, Gorakhpur, Swamso, that is Tata, Bearing Tata, Metallics, Ramco Industries, Ramco Group of Industries, Government of West Bengal consider it proper to make industrial development in the adjacent area of the said lead industries, taking purview of obtaining proposal for fresh industry investment in one hand and socio-economic development on this other, since in this area the people who would depend on this agriculture have been downtrodden mostly for the reason of change in this meteorological climate condition, people and low so development of these people of this area and social economic point of view state at large. But next paragraph, government of West Bengal received the draft proposal for establishment of unit by Telecom Construction Equipment Company Limited near Kharagpur for manufacturing of machineries pertaining to civil construction. Company Telecom Construction Equipment Company Limited was joint venture project of Tata and Hitachi Group, and the company proposed to create and development some other subsidiary units. My lord.
Then his argument is right. On the first judgment cited by him, two sorts of acquisitions, one for public purpose, one for a particular company. This was for this company. Then that has to follow. The company should have paid and the other things should come. But you have not even given to Telcom.
Right?
I'll follow the judgment cited by learned friend, the first judgment cited by him. There it was stated, categorically it was held that there are two kinds of declaration. First place, a declaration may be made for public purpose, in which case the compensation to be awarded for the property to be acquired from public funds. Here it was public funds was utilized. But if it is made for a company in the second instance, then the company has to pay up. If it is for Telcon, why did you mention a public purpose? You had to mention for Telcon. You did mention Telcon and Allied Industries. So it was for a particular company, Telcon and Allied Industries. Then it had to pay. Why should public money be used? Why should the state acquire?
No, my lord. Public money, my lord. What has happened, my lord? The government acquisition of this land of this public purpose at large, my lord, for this industrial purpose. After that, my lord, we are the agency. We are distributed. My lord, this is the.
So this happened after.
After, my lord.
If it happened after, how could you mention in your notice, code 1 notice, that Telcon, it is acquired for Telcon and Allied Industries? Please see your notice, Mr. Adar.
No, my lord.
Your caught there. Please come to the notice. Please come to the notice, page 43. Please come to the notice. Notice is very categorical, page 43 of the paper book. Just see the public purpose at the public expense. You clarify, clearly covered by the Supreme Court judgment, at the public expense for a public purpose, namely employment generation and socio-economic development of the area by setting up Telcon and allied industrial units. So you are referring to a particular company which is a joint venture of two giants in the field, maybe. But then it's this company which had to pay up. You say in the notification at the public expense for a public purpose, and then you say employment generation by setting up Telcon. Telcon is a joint venture of Tata and Hitachi. So they had to pay up. This acquisition process is bad then.
What has happened, my lord? we invited allied of this company, where Kharagpur and Paschim Midnapur.
You invited, you say after the notice. Then how could you forecast that this company would come? In the notice itself, you have mentioned the name of the company. Your intention is betrayed there.
I clarify this portion, and
No.
also consider this judgment, I refer
No for that time.
Yes,
What good arguments today?
and kindly, come to mind, our
As a very
intention-
complete you are placing this. So you say that this is a public purpose and you have given, but you have not mentioned when you received the draft proposal for establishment, before or after the notification. Let us see.
Page number 177 of my operation, everything 177. Para Roman 2. 177 Roman 2. Government of West Bengal received a draft proposal for establishment of unit by Telecom Industry Equipment Company Limited near Kharagpur and manufacturing of machineries, planning, civil construction. The company telecom equipment joint venture project Tata and Hitachi. After that, 178, 178 Roman 8. This is pertinent. To mention further, all this plot of land were handed over to the respective of requiring body WBIDC for purpose of the establishment of telecom and allied industry units Kharagpur, Paschim Midnapur, which has been acquired under notification so. An acquisition department under Paschim Midnapur, Government of West Bengal, so.
How can it be public purpose and Port Telecom together?
I clarify, page number 180, para 11, Kindly, this.
Yes.
With reference to statement in paragraph 4, 5, and 6 of the said petition, government has obtained the help of the concerned department of Government of West Bengal for development of industry economically backward areas of district Paschim Midnapur and access land outside purview of the intensive cultivation as well as those left barren for low irregularities was acquired by this Government of West Bengal to divert land acquisition proceedings, including that pertaining to the present petitioner. The development of such vast area of this land was then taken in the purview of the requiring body, and more to since telecom and allied industry was not able to set up their subsidiary unit in such vast accurate area of land. Kindly mark this paragraph, my lord.
We've already marked, but against you.
The development of this land and industrial park was named as Vidyasagar Industrial Park, which has nothing to do with the acquisition process, as the object of the acquisition remains same even in the change of this name of this industrial park, and same was done by this West Bengal Industrial Development Corporation with approval of government. We are the agency. And we are the agency, whatever may be, change this, this scenario, with approval of this government for end of creation economic zone for inter social economic development and taken in the purview, with permission form, we are the agency, whatever may be, change of this, with permission from this government, we can do anything from this without permission from this government,
See, you acquired the property. There are two components of his first argument. One is that it was taken for a public purpose, given to a private party. You are denying that. We agree with you to some extent that yes, it was taken for industrial purpose, used for industrial purpose. But the other component of your learned friend's argument is that it cannot be. There are two types of this acquisitions. One is for public purpose, the other is for a company. If it is for a company, it cannot be at public expense. The company has to pay up. That is the judgment cited by them.
He is not company.
And here you say simultaneously for public purpose and also for telecom and allied industry. Two cannot go together.
No, Malad,
And at public expense you have written there in the notice.
what is the public purpose? Malad, any industry, my lord, development, any industry, my lord.
Public purpose, you know what is public purpose. Industry is public purpose. You can't understand and question each other. Public purpose, even if you give it to a public for public purpose to a particular company, the acquisition was for a particular company, Telcon and Allied, which you have categorically admitted in every paragraph of your acquisition. It was for Telcon, by Telcon, of Telcon.
That's why, my lord.
So Telcon should pay up. Why at public expense?
My lord, with approval of this government for this creation of the economic zone, my lord, he can't do anything. My lord, we are the agency, my lord. Whatever may be, my lord, we are, my lord, only, my lord, look after of this industry, my lord. We invited to this industry, my lord, with, my lord, approval of this government, my lord. We set up this, my lord.
How does Ganesh Flour and Food come in? They are also an industrial unit. Flour and food is industry. It's industry, but industrial unit. No, they have been entrusted to look after the industrial engineering and manufacturing part.
Yes, my lord, that's why, my lord,
They may manufacture their own products, but they will set up an engineering and manufacturing plant, Ganesh Food and Flour. What is the antecedents of this company?
absolutely, my lord, I agree.
Where do they come in?
Use, my lord. But, my lord, why, my lord, simple, my lord, paragraph number 11, my lord, such area of this land was taken in the purview of the requiring body and most so, my lord, allied industry was not able to set up their subsidiary units in such area and land, my lord. That's why, my lord, we invited, my lord, I specific, my lord. They are not interested, and my lord, they are not able to set up their, my lord, company. My lord. That's why, my lord, we invited this other, my lord, with approval of this, my lord, government, my lord.
So you say clearly change the name of the park. Well, you are saved for the day, Mr. Adok, because we have fixed the matter at 4. You please, Mr. Dotto, please give him the citations.
Yes.
He was not there.
Another copy of the judgment, my lord.
Come prepared, we come back on next.
Yes,
Next person.
the matter is marked as after.
Yes, heard in part for further hearing on January 15, 2026. What is the determination of justice balance?
Well, these are residuary fees.
Supplementary.
Appeal seconds group 9 order.
Matlab,
Appeal seconds group 9 single judge order. This is a fixed matter.
matlab,
You are appealing this matter. Come. What item number 12? Yes, we will. Yes, we will. Reserve bank.
matlab, we repent May I see?
That took leave at 2. Because Justice Banerjee's bench is not sitting that.
I understand.
It was
At
subsequently.
least one of us should have to give the feedback. The point is really very short. I will not take the point of view. I'm not going into the merits of the matter as such. In very short, I will just take a minute. Certain penal charges were levied on the appellant, which was a borrower, in violation of the RBI master circular. So, account was sought to be declared an NPA.
Court circular or
This is in the circular on levy of penal charges.
This is another circular.
Another circular.
We are alien.
No, we immediately filed a writ petition. We made out a case. We obtained an interim order. In the meantime, the learned single judge was pleased to observe that this is a matter which can be settled between the parties. He was given to the parties to settle the matter. Thereafter, Lordship, several attempts were made at settlement. In the meantime, the interim order was extended from time to time and pleadings were exchanged. All affidavits filed, affidavit in opposition, affidavit in reply filed. Now, finally, Lordship, after several failed attempts, a one-time settlement was reached when the petitioner, the appellant, found a buyer for its loan liabilities. Now, Lordship, the OTS was sanctioned and first tranche payment was made, but the second tranche payment could not be made.
First tranche means 81 lakh.
But that 81 lakhs is what we couldn't pay. This is the next leg, Lordship. And first, there was an OTS
539
Lordship. We could not be paid because our first buyer backed out. So thereafter, we got another buyer, and this time it was the State Bank of India. So when the matter came up before the learned single judge, the learned single judge said that I am extending the interim order only till 6th of January. I want to see you making that next tranche of payment of 81 lakhs by 31st December. Now, unfortunately, Lordship, what happened?
You ready with the money?
But now, Lordship, what has happened is on 30th December night, State Bank withdrew from the arrangement. So it left me with 1 day to pay that 81. Now I could not pay that 81.
State Bank withdrew from the arrangement. It was a tripartite thing.
No, it was an arrangement between me and the State Bank. If the South Indian Bank is not involved, the respondent here, that I must be fair. So they withdrew on 30th December and we could not pay that money. Now, Lordship, when we had an interim order till the 6th of January, when the matter came up on the
withdrew means in what capacity was the State Bank involved?
Well, the State Bank would absorb my liabilities. It would pay off the loan on my behalf in exchange
that
for.
That was the scope of the one-time settlement, according.
That was the scope of the one-time settlement.
From your end, you involved.
I will pay.
South Indian Bank had
is not concerned with the State Bank.
Anyway, so for that reason, they could not pay.
We could not pay.
Then
now the interim order was subsisting till 6th of January. So when the matter came up on the 6th of January, Lordship, the appellant was left with one option, which is to argue out the matter and finish it. Both the parties and Mr. Probal Mukherjee was appearing to the bank when he was ready to argue the matter. Now, Lordship, there was paucity of time on the part of the court, which is why the matter could not be heard on that day. So the matter has been fixed on 15th January. Now, but the interim order was vacated, it was not extended. Now, because of that, Lordship, what has happened? Only the final hearing is left. For me, I will require an hour to conclude my submissions finally. It may be recorded that no adjournment shall be granted under any circumstance. I will go and finish the matter on my part, on the part of the appellant.
81 lakh, what about that?
But for that, I'm told I'm taking instructions. 15 days would be required to pay the 81. Now, if my short
this is not a judgment under the latest patent. That obvious objection as to maintainability, rather the objection as to maintainability is very obvious. This is not a judgment.
But it's my stage. But
at 32 stage, 13.4 has been done.
But my only contention is this.
And 13.4 is on a different footing. This is on a master circular.
This is on master RBI circular.
RBI master circular.
Initially, 13.2 we could not proceed since they were.
13.2, 13.4 has nothing to do with this.
No.
Held repeatedly by several courts. 13.2, 13.4 is on a different.
Only we could not enforce the 13.2.
You are who? The South Indian.
We could not enforce the 13.4 because there was an injunction. Injunction was vacated. We have done the 13.4.
13.4 has nothing to do with injunction. That penal provision, what was done? Your name was uploaded somewhere.
No, it has not been uploaded till now, but it will be done now. But it will be done now.
No, you have. What is the impugned decision? You have been declared to be
the declaration of NPA.
Classification of
But
You challenge the classification as NPA.
Malak, we actually challenge.
Entry model was
We challenged the levy of the penal charge, the consequence of which was the declaration of NPA. May I just clarify what happened? We were supposed to pay a certain amount to keep our account standard. We received a communication from South Indian Bank saying, please pay X amount of 40 lakhs odd to keep your account standard. We paid 40 lakhs and another 5 lakhs odd on that date when I was asked to do so. What happened? This was a Sunday evening. On a Sunday evening, without any notice, additional penal charges were deducted, thereby my account crossing the credit limit. And immediately NPA declaration was sought to be made. I challenged
the imposition of penal charges was additional penal charges.
the imposition of the penal charge is the cause for everything that has happened here, not the servicing of the interest, because the interest was serviced as per their communication, and this is all on record. In fact, seeing that particular communication, did we obtain a stay before the learned single. Now, all that lordships I was praying for is the matters fixed on the 15th. At the final hearing stage, we've enjoyed an interim protection. Otherwise, the matter becomes infructuous because if they proceed now and take possession of my assets, nothing really is left in the matter. All that I was praying for is till the matter is heard out on the 15th, let me have an interim protection.
So, I will be opposite tribunal. Now we understand the justification of your friends out. Because you're trying to stall 34 that measure.
But I enjoyed an interim order which was passed by this honorable court based on a prima facie case which I made out.
But that was only on condition that you pay the amount.
Not initially, Lordship. Initially, it is only on the basis of penal charges. Thereafter, because the settlement talks were going on, was this decided. Now, either Lordship kindly.
What is the error in this order? That in an intercourt appeal we shall interfere.
The error is only this, Lordship. It is really on equity. 1 day of hearing is left in the matter. We have kept the matter relevant till now because of protection we've got from court. If that protection were to go, now what purpose would be served by the final hearing? Because there will be multiplicity of proceeding. I would have to approach various other fora and get relief, whereas I was enjoying an interim order since October 2024, and for legitimate reasons. The interim order was never extended with opposition from the bank.
The interim order initially granted was extended previous to this.
Lordship, several extensions were there.
At no point of time you are directed to put in any amount.
Lordship, because the settlement talks were wrong between the bank and the petitioner.
That's why you have got the advantage.
Lordship, so now, Lordship, all that I'm praying for is, Lordship kindly keeps the matter tomorrow. Tomorrow I will finish the argument. But tomorrow, Lordship, the interim protection. Otherwise, Lordship, because of 1 day of hearing being left, my entire matter becomes infructuous. Lordship will kindly consider the. We've come with folded hands. Lordship can understand by looking at my case, Lordship. That's the only protection.
By looking at my case.
We've come with folded hands, Lordship.
We did not come with folded hands, but what do you say, Mr. Pramanik? Understood.
Today,
but here we are not. See, this is not. You are right in saying, in a sense, that this is not an intercourt appeal scenario. But the
11 crores we will not have settled.
11 crore.
11 crores. OTS proposal has been cancelled. The lordship takes the last page.
11 crore, how soon can it?
But 11 crore.
You can take instruction. 81 crore, 15 days.
But
11 crore should be within.
But 81 lakhs and additional 5 crore 25 was to be paid by 28th February
81 lakhs, sorry.
And 5 crore odd.
There is no question. And no, see, Mr. Pramanik, this order was initially granted. That was being extended from time to time.
On the ground that he would pay. He would pay. 30th November was the last day.
Yes, but 15 can be fixed for hearing if the interim order.
No, he did not pay the grant.
No, he paid 5,39,000 he paid.
He paid the initial first installment. Thereafter he failed. 30th November, 30th December. Thereafter he was.
He has given some ground for failing. I mean.
No, he did not give any ground. What he is doing, he has accepted the one-time settlement.
So he says that on 30th night.
What I will say. He accepts the one-time settlement. Thereafter he put some clauses again. These are the grounds that we cannot do a one-time settlement. You have to extend.
This was done several times.
The one time.
Then 30th December only they say they give it out.
That is, if I can show the documents, will not
I do not remember the page in this appeal, but I can show the documents from the trial court.
The documents regarding
That interim order was extended and thereafter he was granted time on the verge of payment. He prayed for time to pay till 30th December. He failed. Thereafter, the matter was mentioned before Justice Krishna Rao. Lord, his lordship directed them to make some payment till January. He did not. He failed. Thereafter, we have taken interim order was vacated and the matter was directed to finally happen. So today, my lord, at this stage, my lord, 11 crores and order due. Lord, he has to deposit some amount or 11 crores and so that we can.
no question of 11 crore because even that will go beyond the interim order itself.
So then I'm challenging his mentality of the appeal because 13 crore has already been done. Lord, he has a right before other forum. And Lord,
no, here it is not a question when we are considering as a writ court that for the first time whether we should grant injunction. There was an injunction, it was vacated on a particular ground. That ground, this seems to be onerous, which renders the main, the original order of ad interim order infractions.
His lordship now takes Justice
This
Krishna
ground is onerous. Justice
Krishna
Krishna Rao himself had granted the ad interim order.
No, ad interim order by extended.
Someone else, some learned single judge had granted. Whoever judge is not important.
Two times Justice Krishna Rao had extended the time.
Whoever, the learned single judge initially granted ad interim order, which was extended from time to time. There was a one-time settlement, which you now say it has failed also. So therefore, on the premise of that one-time settlement, this amount was directed to be put in by them. 5,39,000 they had paid. In terms of that one. So their bona fides are not directly in dispute here.
Lord, if they want to pay, Lord, they are liberty. We will not charge them. But there is
no, but till
intention.
15th we feel that there should be a stay. We will interfere with you.
Lord, we have already taken.
Taken what?
Possession.
Possession has been taken.
When we mentioned the matter, we stepped
What
out.
was the interim order granted?
Not to take any course action.
Not to take any coercive steps.
Then
Now,
was already
now what has happened, Lordship, is there has been no
taken possession. Then it has
Lordship, what has happened is
The bank shall not proceed further with respect to the secured asset is 21st November 24 article decision is arrived at.
they have already taken.
Malad, may I, Malad, after we mentioned the matter, when we went to serve, we took instructions from the client. We are told that
now possession is already taken.
Malad, only a notice has been pasted, but no publication under 13.4 has been made as such. It's only a notice which has been pasted. We have also not received it. All that we want is no further steps to be taken till at least
He has the time.
Mr. Pramanik will do this. Will not interfere with the order as such, but we'll ask you to maintain status quo in respect of the property till 15th January.
He has the right.
Whatever has been done
For
has
60
been done.
days, he has already arrived.
Lordship, there I have a question.
Not created a third party interest, we'll just grant us.
Only possession has been taken.
See, possession has been taken. This interim order we won't, because that would be interfering with the order of the court. We won't interfere with the order. We'll request the learned trial judge, learned single judge, if possible, to take up the matter on 15th of January, and it has already been directed to be.
But I have only one submission in that case. Lordship.
We'll record that possession has been taken.
Lordship,
Say no.
Lordship, may I make one submission in respect of the 13.4 notice?
Yes.
Malad, after the 13.2 notice is issued, there is a 60-day period. We have to discount the period during which there was an injunction from the learned single judge. If that is taken into account, the 60-day period has not even ended. 33 days are left.
Whatever may be because that
will be subject. It would be non-S, the 13.4.
No, that would be decided in the petition itself, Mr. Short.
But only kindly protect that nothing be done with the property at least till the matter is heard.
That is what we are saying.
Great. I have nothing further to say.
The present challenge, the present leave was granted to file the present appeal without a certified copy, and the matter is being taken up on an urgent basis on very short notice on the respondents in view of the extreme exigency pleaded by learned counsel for the appellants. Full sub next para. The appellants challenge an order, an ad interim refusal, challenge an order whereby an ex parte order of injunction granted earlier by the writ court, which was previously extended from time to time, was vacated on the ground that, pursuant to the previous direction of the writ court, the writ petitioner stroke appellants had failed to deposit an amount of rupees 81 lakh. So, next para, the genesis of the challenge is a penalty, an additional penalty imposed on the appellants by the respondent number 1 bank, which according to the appellants was dehors the law. Full stop. Next para. It is contended by the appellants that due to such imposition, comma, the appellant's account exceeded the credit limit, comma, thereby exposing the appellants to the labeling of their account, to the classification of their account as NPA within bracket non-performing asset. Bracket close. Full stop. Due to such classification, comma, it is argued that measures under Section 13 of the SARFAESI Act were initiated by the respondent number 1 bank. Full stop. Next para. The premise of the writ petition was the allegedly unlawful imposition of additional penalty and the consequential actions taken on the basis thereof. Full stop. Next para. Although initially an interim order was granted by the learned single judge, comma, subsequently settlement talks were going on between the parties. Full stop. The parties had arrived at a consensus ad idem in respect of one-time settlement, comma, by virtue of which the appellants were to remit an amount of rupees 5,39,000 within February 28, 2026, which the appellants complied with. Full stop. However, comma, in the second tranche, TRANCHE, comma, the appellants were to pay to the respondent number 1 bank an amount of rupees 81 lakh by December 31, 2025, which the appellants failed, comma, prompting the learned trial judge to vacate the interim order. So next parallel, learned counsel for the appellants argues that the amount could not be paid, comma, since there was an arrangement between the appellants and the State Bank of India that the latter would cover the said amount, comma, from which assurance the State Bank of India allegedly withdrew in the night of December 30, 2025, comma, thereby jeopardizing the chances of the appellants to pay such amount to the present respondent number 1 bank. Full stop. Next para. Learned counsel thus submits that since the writ petition itself has been fixed for hearing on January 15, 2026, when the appellants are fully prepared to advance their arguments, comma, which they were also prepared on the date of the impugned order, comma, an interim order be granted for a limited period to protect the interests of the appellants. Full stop. It is submitted that otherwise, comma, the writ petition itself will be rendered infructuous. Full stop. Next para. Learned counsel appearing for the respondent number 1 bank vehemently opposes the prayer and submits that extremely short notice was given to the respondents before moving the matter before this court. So it is further submitted that the respondent number 1 bank has already taken measures under Section 13 within bracket 4 of the SARFAESI Act by taking possession of the secured asset, taking possession of the subject property of the appellants. So next para, as such, comma, in any event, comma, the interim order granted by the writ court, comma, it is submitted, comma, has become infructuous. So next para, even otherwise, comma, it is alleged by the bank that the dues of the appellants are to the tune of rupees 11 crore, comma, only upon payment of which can the appellants seek any interim order. So next para, even otherwise, comma, it is contended that the prayer for injunction is barred by the provisions of the SARFAESI Act, comma, since proceedings under Section 13 within 4 of the said Act have already been initiated and culminated in possession being taken. So next para. Upon hearing learned counsel for the parties, comma, we find that the impugned order does not tantamount to the judgment for us to invoke jurisdiction in an intra-court appeal under the latest patent. Next para. However, comma, at the same time, comma, we appreciate that the appellants have sought to made out an apparently plausible ground for not being able to honor the commitment of payment of rupees 81 lakh by December 31, 2025. Full stop. Next para. The learned single judge proceeded on the premise of such non-payment to vacate an ad interim order which had previously been granted and had been extended from time to time, thereby leaving the appellants in the lurch altogether, despite the writ petition itself being fixed on January 15, 2026 for final hearing. Full stop. Next para. In such view of the matter, we are of the opinion that the interest of the petitioners stroke appellants ought to be protected to a limited extent, at least till the next date of hearing before the learned single judge, to the extent that the respondent number one bank should not create any third party interest in respect of the subject property. Full stop. Next para. Accordingly, MAT 27 of 2026 is disposed of without interfering with the impugned order dated January 6, 2026, passed in WPA 25431 of 2024, but restraining the respondent one bank from creating any third party interest and or encumbering the subject property, of which possession has been taken pursuant to section 13 within bracket 4 of the Surface Act by the respondent number one bank, till January 31, 2026, or until further order as passed by the learned single judge, whichever is earlier. Full stop. It is made clear that it will be open to the learned single judge taking up the writ application to vacate, vary, modify, and or extend this order as per the discretion of the learned single judge. Full stop. However, keeping in view the fact that the writ petition has been fixed under the heading specially fixed matter at a designated time, that is 12 noon on January 15, 2026, this court is confident that the learned single judge shall conclude the hearing of the writ petition on the said date. Full stop. The parties are requested to cooperate in that regard. Full stop. Can such and such 1 of 2026 is also disposed of. Consequentially, no arrest to cost. The parties shall act on the server copy of this order without insisting upon prior production of a certificate.
Only to sort one logic recorded ex parte ad interim order. The initial order was also passed after hearing the bank. And lordship regarding the 13.4 notice, because I have my representation under 13.3A, which has not been considered, but because I submitted it today.
Keep the questions open.
That those questions can.
It is made clear that the merits of the matter, merits of the subject matter of the writ petition have not been entered into at all, and all questions, including the legality of the steps taken under section 13 within bracket 4 of the Surface Act will be open for being argued by the parties before the learned single. Regarding
State Bank of India, what the document says that here, as per the State Bank of India, we do not have any.
Since no affidavits have been invited, it is made clear that none of the allegations made in the in Can 1 of 2026 are deemed to be admitted by the respondents.
Grateful, man. Grateful.
Somewhere we'll put in that no, vehemently opposed. That is the beginning.
No, because tomorrow they will say that State Bank, we knew that State Bank of India is
No, how can this?
No,
We have
not
from
even-
our order they won't be able to.
because in the writ petition nothing was there. The State Bank of India is coming.
So you can point out to the learned side. He cannot say that on the basis of our order.
No,
We have just recorded their submission.
Grateful, my lord.
Thank you.
Grateful.
What is your group? You are appealing in the other order.
Item number 30.
What is
Opinion lordship is mine. Perhaps only one question. Can this be on top of
Top slot is already booked. The 3 tops.
Then the middle slot maybe.
No, come on. Come on. You are already in that slot. You're already in
But
that.
I appear for the respondent, my lord, in this matter.
Yes, Mr. Chatterjee. But we are on slots now. But you're already on a top list.
Uh,
You will record some order. You are appearing. All of you are appearing in one line order that cannot take it up. Although the matter called on for hearing, comma, the same cannot be. The hearing cannot be concluded today in view of paucity of time. So, accordingly, let the matter stand adjourned till January 15, 2026. To retain its position.
ready.
Take it. After the lab, again.
Oblige, my lord.
Hey,